Good morning, ladies and gentlemen. Welcome to Hong Kong Legal Week 2024. The second legal forums on interconnectivity and development will commence shortly, so please be seated. So just a gentle reminder, please kindly turn your mobile phone into silent mode. The event will be conducted in Putonghua and English, with simultaneous interpretation in English, Cantonese, and Putonghua. So you can pick up a SI headset at the entrance of this hall. Please select Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for Putonghua. And for online participants, please choose your preferred language by clicking the language button on the sidebar. 各位來賓，大家早晨，歡迎大家嚟到2024年度香港法律週第二屆融通與發展論壇即將開始，有請各位盡快就座。溫馨提示：請各位將你哋嘅手提電話調至靜音模式。咁今次嘅活動呢，將會以普通話同埋英語進行㗎，並且提供同聲傳譯服務。大家可以喺會場入口嗰度領取即時傳譯耳機，頻道1係英語，頻道2係粵語，頻道3係普通話。而線上嘅參加者亦都可以點擊直播畫面上面嘅語言按鈕，選擇你嘅語言。各位來賓，大家早安，歡迎大家莅臨2024年度香港法律週。第二屆融通與發展法治論壇即將開始，有請各位盡快入座，並把你們的手提電話調至靜音模式。本次的活動會以普通話和英語進行，並提供同聲傳譯服務。大家可以在會場的入口處領取同聲傳譯耳機。頻道1是英語，頻道2是粵語，頻道3是普通話。線上的觀眾也可以點擊直播畫面上的語言按鈕，選擇你的語言。謝謝大家。 Commissioner Choi, Secretary Lam, Mr. Lineot, Your Excellencies, Council General, distinguished guests, ladies and gentlemen, good morning. Welcome to the second Legal Forum on Interconnectivity and Development, an event of Hong Kong Legal Week 2024. This forum is co-organized by the Commissioner's Office of China Foreign Ministry in the Hong Kong Special Administrative Region and the Department of Justice of the Hong Kong SAR. Thank you very much for joining us here in person and joining us online. My name is Ivry Yao, and it is my absolute honor to serve as your MC for today. And now, ladies and gentlemen, to kick off today's forums, I would like to invite Mr. Cui Jianchun, Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR, to deliver his welcoming remarks. 我们掌声有请崔建春特派员上台为我们致欢迎词，掌声有请。
Secretary Paul Lam Dingguo, Mr. Alberto Nino, the General Counsel at the Asian Infrastructure Investment Bank, Honorable Counsel Generals, ladies and gentlemen, I'm very delighted to have this great opportunity to share with you about this very important topic, interconnectivity and development. I know that everybody, every society, every nation are focusing on development. And development is of the main theme for the international community. And President Xi Jinping proposed a great global development initiative in the year 2021. So I'm thinking that why the Chinese president has a proposal to the international community, we should start from 2013. That's the first time President Xi Jinping proposed the Belt Road Initiative in the year 2013, September and October in Kazakhstan and Indonesia. So today, I think this topic is related to every development of all the nation. In the year 2013, the essence of BRI, I hope that everybody could know that we have three principles. One is extensive consultation, and second is joint effort. The third is shared benefits. And also we have we call the 5 connectivities. The first is about policy coordination. Second is about infrastructure connectivity. And the third is about unimpeded trade and investment. And the fourth is financial integration. And the last one is people-to-people's exchange. So this 5 connectivity also is topic today. We are discussing about the interconnectivity. So I do believe today's topic is very important for Hong Kong, because Hong Kong can play a very, very important role for our integration or interaction or interconnectivity, because we believe Hong Kong should be and must be and will be dependent on mainland China and also the international community as well. So that means without the interdependence, nobody, no country, no society can make progress or make prosperous society. So this reason, I do believe that interconnectivity is of paramount importance for our development. So my colleague prepared I should read the text for everybody. So good morning. I'm very delighted to attend the second legal forum on interconnectivity and development. This is the second legal forum co-hosted by the Commissioner's Office, my office, and the Justice Department. I would like to express my gratitude to all the old and new friends for supporting this forum, and extend my warm welcome to all participants, both online and offline. I think that everybody admit that the world is undergoing unprecedented change. So today's keyword, change, change, and change, with the deepening multipolarity and economic globalization. I know that we're discussing about the multipolar world and also the economic globalization. We are facing the great challenge. How can we build a new order? How can we build a new multipolarity and economic globalization? Countries are becoming increasingly independent. So some countries say, we should not depend on your effort and your contribution. But we know that without the interdependence of every nation, we not only to survive, I do believe there is no opportunity for thrive. So in today's world, connectivity is an unstoppable historical trend. Development is a common pursuit of the international community. I travel all over the world, especially Latin America, Africa, ASEAN countries. We do know what's the meaning of development, especially about material things. That means how can we work together? This is the reason why the common pursuit of the international community and the rule of law is a vital component of countries' competitiveness. I just share my thought with the Secretary for Justice. We think that the Hong Kong strength, the rule of law is strength of Hong Kong. Why? Because without the rule of law, without the awareness, without I think that the obedient to rule of law, we cannot only make a stable society, we cannot make big deal for economic sector, the most important thing for the culture sectors. As a highly open ceremony that connects China with the world, Hong Kong possesses unique advantage that fit the globalization trend, but at the same time, face the task of leveraging legal means to safeguard development rights and expand the development space. We're discussing about the relationship between security and development. Here we believe that without the rule of law, we cannot achieve security. That means the security development is interrelated and also should be interconnected. In July this year, the third plenum of the 20th Central Committee of the Communist Party of China adopted a resolution which includes strategic arrangement for further reform and advancing Chinese modernization. Yesterday, I shared the basic idea about the resolution adopted by the third plenum of CPC 20th Central Committee. Today, I want to share you the big figure. I think that is important for everybody here. China now accounts for 18% of the globe GDP. That means U.S., I think, approximately 25. So that we still have 7%, that's the gap. So now, and also the first figure of 18% of the total GDP, according for the global, we can say global global figure. The second is about China now, we contribute still 30% economic to the international community. That means China, Hong Kong is of paramount importance in economic sectors. I do believe that General Council, you have a lot of figures here. This is the reason why China matters a lot to the international community, not only because of the huge market. Most important, we have a very, not only the modern productivity, we are try to achieve the new quality productive force. That means the 18% and also 30% for the Chinese economy. And the most important thing that we believe the advancing China modernization and the strengthening rule of law is a key part of the resolution. How can Hong Kong capitalize on the rule of law to achieve new development. My answer is try to seize threefold opportunities. The first opportunity is from the improvement of Hong Kong's rule of law environment. The rule of law is a core value affirmed by the Basic Law and serves as a strong foundation of Hong Kong's long-term prosperity and stability. Article 23 legislation has been completed, and it better safeguards the rights of Hong Kong residents and Hong Kong's business environment and international exchanges. I want to share my observation. I work in Hong Kong just the past 6 months. So after passing the Article 23 legislation that's safeguarding national security ordinance, and some people say, oh, there's no change. There is no hindrance. There is no impairment for the Hong Kong's custom, Hong Kong's way of life. And I want to share with you, this is the truth. But we have to, people sometimes focus on the negative side. But I want to let you know, the national security law and also safeguarding Hong Kong national security ordinance not only change the way of life, it protects the way of life. When I talk to the Consul General's Chamber of Commerce, everybody recognize the security law, security ordinance, not only protect, not only the people's life, the property, promoting the business environment, and the most important thing that now we have a secured society, we have a stable society, paving the way for the way of life. So I think that this is very, very important now. We call it rule of law, that we have this true law is very fundamental for Hong Kong's long-term development. As safe, stable, and promising Hong Kong will continue to be a favored destination for investors from around the world. In these days, I discussed with the Chamber of Commerce, the chairman of the Chamber of Commerce. We know that it's high time for the business people to invest in Hong Kong, to invest in Greater Bay Area. I do believe business people can do good things for the people. Sometimes some politicians create chaos for the society, for the relations, geopolitics. I do believe that the rule of law in Hong Kong, the environment is good. It's good for everybody. It's good for every business. The second opportunity is from the great importance China attaches on the rule of law. So we know one country, two systems, one country first. Without one country, there's no two systems. So this is the reason why Hong Kong has great advantage, why international community, including diplomats, business people, and tourists, they believe Hong Kong, the great importance, we have the big, not only market, we have a big homeland, the mainland, to support Hong Kong, the development. So the rule of law is essential for Chinese modernization. China is now advancing both domestic and foreign-related legal frameworks, improving rule alignment in the Greater Bay Area, and cultivating legal professionals in international law. This will help enhance Hong Kong's legal expertise and invigorate its legal service sectors. I also want to highlight mainland China is counting on Hong Kong's rule of law. This is a foreign-related law. We are striving and try to build our nationals related the law, and Hong Kong really can do a lot for this development. The third opportunity is from the development of global governance. The rule of law is a core tenet for global governance. I do believe that we are facing the challenge of global governance. So every nation and try to, there is no copyright, and also there is no restriction for every country. How can we strive to get the national governance in the national context and national conditions. So under the one country, two system framework, Hong Kong enjoys a unique status to participate in international rule negotiations and multilateral mechanisms like the WTO. In the future, Hong Kong will play a more important role in improving global governance and will have more favorable external environment for development. I also want to share with you my understanding in the coming 5, 10, or 15 years. I do believe Hong Kong can do more contribution to the global governance because here only Hong Kong as an internationalized city have one country, two system. I hope that everybody yesterday I shared with you know what's the meaning of free, know what's the meaning of independent, know what's the meaning of sovereign, know what the meaning autonomous. So Hong Kong, that if you understand the definition of these 4 English words, you really would understand what's the meaning of one country, two system. Ladies and gentlemen, strengthening the rule of law is crucial for China to pursue Chinese modernization. So in China, we have a very important emphasis. We will do that rule of law. We use a comprehensive rule of law. So it is crucial for Hong Kong to achieve new development here. I would like to share my suggestion, summarized as 3 C words. The first C word is competitiveness. Competitiveness. Hong Kong needs to reinforce competitiveness in the legal field and build itself into a preferred destination for global dispute resolution. Supported by national policies, Hong Kong is developing into an Asian-Pacific center for legal and dispute resolution service. The ALCO Hong Kong Regional Arbitration Center is the coming Hong Kong International Legal Talents Training Academy, which will be launched on this Friday. I think this is a very important institution. The international community, we discussed just now about how can we get more the legal persons, especially from the government, to come to Hong Kong, to let them know seeing is believing. I think that is not only good for Hong Kong, and it's good also for mainland and for international community. We believe that will further enhance Hong Kong's legal competitiveness. Recently, negotiations on the Convention for IO met that were successfully concluded in Hong Kong, and a signing ceremony is scheduled for next year. We will fully support Hong Kong in strengthening mediation services and help build Hong Kong into the capital of mediation. I also want to, at one point, the third avenue. One is litigations, second is arbitration. Hong Kong will provide the third avenue of vehicles for mediation, the International Organization for Mediation. And I do believe next year you will find Hong Kong's contribution to the international community. Now we have 19 member states have signed the convention of this very important international organization. And next year, I hope, and we will say, the official operation of this organization. So here I thank you, the director of the preparatory office here. He has made a great contribution to make it a reality for this mediation. So that means litigation, arbitration, and the mediation will be the 3, but we have to recognize the mediation is complementary to the litigation and arbitration. Most disputes are solved by the litigation or the arbitration. So the second C word is connectivity. So we believe today's international community connectivity is of paramount importance. Hong Kong needs to improve connectivity of the rules and standards to support China's international opening up. We believe opening up is a secret is key of Chinese development. So in today's geopolitics, we cannot close the door. We have to open the door wider to the international community. You cannot say, okay, we will protect our society, protect our productivity by closing the door. Chinese has the right, has the reason to share with you that we, in the Qing dynasty, inefficient government and corrupted government really closed the door. This is the reason we suffered more than 100 years humiliation by the big powers. So that means the open up is of not only the key of China. I think that is suitable to every nation. As a free port and separate customs territory, Hong Kong implements high standard trade rules and regulation, making it a testing ground for strengthening connectivity of cross-border legal frameworks between different law systems. So we are proud in Hong Kong we apply common law. People believe common law is in favor of business sectors. This year, a new service, trade management, was established between the mainland and Hong Kong. Looking ahead, we believe Hong Kong will fulfill its role as a super connector and also super value adder to strongly support China and Hong Kong's institutional opening up. The third C word is confidence. Hong Kong needs to boost the confidence in the rule of law to promote mutual learning between Chinese and Western or other nations' legal cultures. Hong Kong is a melting pot of Chinese and the international community, the legal traditions. Since Hong Kong's return, China's constitution and the Hong Kong basic law have formed the foundation of Hong Kong's common law system. Despite external, not only threat, sometimes coercion, and sometimes I hate to use words, the libel or slander, whatever, to Hong Kong's judiciary, to Hong Kong's independent judiciary and Hong Kong judges. Hong Kong's legal system has demonstrated strong resilience. I do hope that people in Hong Kong and the international community, rule of law, independent judiciary, I said is not only the strength of Hong Kong, it is the strength of Hong Kong. Without rule of law, I do believe the international community do not like investing in Hong Kong because investment should be predictable. Investment should be in the stable society. So we need stable society, and also we need democracy. So we will support Hong Kong in an expanding international legal exchange and telling the rule of law stories of the country and Hong Kong to the world. I want especially thank to the chairman of Chamber of Commerce from UK, from US, European Union, ASEAN countries. I do believe that your decision in Hong Kong is right. This is not only for your business, not only for profit. Hong Kong needs your benefit. Mainland needs your investment. And I do believe in today's situation, business people play a very important role because some politicians is not fighting for the national interest. They are fighting for the personal party, group interest. So this is the reason we should commend the contribution of business people in Hong Kong. Ladies and gentlemen, Hong Kong stands at a critical juncture for new opportunity. It must further leverage its unique strengths in rule of law to seek greater development. The Commissioner's Office is ready and willing to work with all of you to help Hong Kong achieve new success and also make new contribution to national development. In conclusion, I want to thank you again for this very important forum, Interconnectivity for Development to Development. I wish this forum a great success. I thank you all for your kind patience and attention. Thank you.
Thank you very much, Mr. Choi. Please remain on stage. Please remain on stage. And please kindly proceed to the center of the stage first. 好，有请崔先生可以移步到舞台中间的位置。Thank you very much for your kind remarks. 那么马上会进行合影的环节，首先有请香港特别行政区律政司司长林定国先生，掌声有请好吗？接下来邀请中华人民共和国外交部驻香港特别行政区特派员公署副特派员方建明先生，有请方先生，掌声有请。香港特别行政区律政司副司长张国军先生，有请张先生。现在有请亚洲基础设施投资银行总法律顾问倪博图先生 ，Mr. Alberto Lineo, please come up on stage. Let's welcome Mr. Lineo. 下面有请国际调解院筹备办公室主任孙静博士，掌声有请孙博士。下面有请香港特别行政区律政司国际法律专员丁国荣博士，有请丁博士。好，有请丁博士来到台上。好。以及本次论坛的所有主持人还有讲者也一同来到台上。Can I please invite the moderators and also the speakers of this forums? Please kindly join our VIPs on stage for a group photos. Should we all give a big round of applause to our moderator and speakers as they're going to enlighten us with their insight and a lot of knowledge today. Welcome you all. So let's make sure all of our guests is already on stage. So let's stand slightly closer with each other. 请大家再一次站得再靠近一点，然后看一下中间那位摄影师，再来一张合影。请大家保持笑容。Alright, so please kindly stay for our media friends as well. Okay, so please kindly stay for one more photos. And also our videos as well. All right, a big round of applause for our guests on stage. Thank you very much. So please kindly be seated off stage. Thank you very much. Thank you very much for supporting our event today, sharing with us your insight and a lot of important information and knowledge. Thank you very much. So today we have prepared fruitful programs for all of our audience here who are joining us here in person and those who are joining us online. So later we're going to have our keynote remarks by our esteemed speakers. So he's going to talk about promoting good governance and high quality development under international law. And now, ladies and gentlemen, without any further ado, let's welcome Mr. Alberto Lineo, the General Counsel of the IIB, to come up on stage to deliver his keynote remark. Let's welcome Mr. Lineo.
Good morning. Good morning, Honorable Commissioner Sui Jianshun. Good morning, Honorable Secretary of Justice for Hong Kong, Paul Lam. Good morning, ladies and gentlemen. First of all, I want to thank you very much for the kind invitation for me to be here again since yesterday. And I was just joking a little bit with Commissioner Sui Jianshun that he set the bar very high because he already said everything that I wanted to say, especially because at AIIB, the Asian Infrastructure Investment Bank, we have three pillars. The first pillar is green finance. The second pillar is connectivity with Asia and within Asia. And the third pillar is the development of private sector. So Hong Kong is simply the best place for us to talk about high quality development. So I hope you've been enjoying this legal week as much as I have. It is very refreshing to be able to get out of the office with the sole purpose of learning from practitioners like yourselves, and as I heard yesterday. Let me first express my deep gratitude to the Hong Kong Department of Justice and other organizers for this kind invitation extended to me to speak before you today. We at AIIB are very proud of the excellent cooperation we have maintained over the years on multiple levels with the Hong Kong government and particularly with the Hong Kong Department of Justice. I was asked to address the topic of good governance and high-quality development under international law. Good governance and high-quality development are essential for sustainable growth and prosperity of nations. To ensure that resources are managed efficiently, institutions are transparent and accountable under the rule of law is upheld. International law plays a crucial role in connecting, promoting, and safeguarding all these principles. Firstly, I believe it is important to unpack and describe the key elements of what governance means in the context of international development. As a conceptual framework, in my view, good governance ensures that decision-making processes are fair, inclusive, and responsive to the needs and aspirations of the people. International law provides a critical framework for promoting and protecting these principles through effectiveness and efficiency, which means good governance requires institutions to be efficient, and also that the agreements are established with standards and guidelines for governance practices. Good governance underpins the effective and responsible management of public and private institutions. It encompasses a set of key elements that contribute to transparency, accountability, participation, and the rule of law. Understanding and implementing these principles is crucial for promoting good governance practices. While one could come up with a long list, I have selected a few points that I'd like to share with you today. First, and in no particular priority order, transparency. Transparency refers to the openness and accessibility of information, decisions, and processes. It involves providing clear and timely information to the public, ensuring that decisions are made in a transparent manner, and promoting accountability. Transparent governance allows citizens to understand how decisions are made, how resources are allocated, and how public institutions operate. Second, accountability. Accountability is the obligation of individuals and institutions to take responsibility for their actions and decisions. It involves mechanisms for holding public officials and institutions accountable for their performance, ensuring that they act in the best interests of public. Accountability also includes financial accountability, performance accountability, and legal accountability, as it's obviously the knowledge of all the presents here. Third, something that Commissioner mentioned a few times in his speech today, the rule of law, which is very easy to perceive here in Hong Kong. The rule of law is the principle that all individuals and institutions are subject to and accountable before the law. It ensures that laws are applied equally and fairly and that legal frameworks are transparent and accessible. The rule of law provides a foundation for good governance by establishing a predictable and stable environment, protecting human rights, and promoting justice and fairness. The fourth one, effectiveness and efficiency. Good governance requires institutions to be effective and efficient in delivering services and achieving desired outcomes. It involves the proper management of resources, the use of evidence-based decision-making, and the implementation of sound policies and practice. Effective and efficient governance ensures that public and private institutions can meet the needs of the people and achieve their objectives. Fifth, and perhaps a very, very, very important one, ethical conduct. Ethical conduct is an essential element of good governance. It involves adhering to ethical principles such as integrity, honesty, and fairness. Ethical governance requires individuals and institutions to act in the best interest of the public, avoid conflict of interest, and maintain high standards of professionalism and integrity. These key elements provide a framework for responsible and effective governance in both public and private sectors. By embracing and implementing these elements, institutions can promote trust, legitimacy, and sustainable development, ultimately benefiting society as a whole. Under the vast but the just discussed solid principles of good governance, social and economic development can take hold and prosper, develop into high-quality development focusing on achieving sustainable and inclusive growth and benefit all members of society. It emphasizes the importance of economic, social, and environmental dimensions, ensuring that development is not only economically viable, but also socially just and environmentally sustainable. International law provides a framework for promoting and regulating development activities, ensuring that they adhere to principles such as human rights, environmental protection, and social and economic justice. At this point, I'd like to further illustrate this discussion by highlighting 3 points that play a vital role in the business that I come from, which is international development, which is promoting high-quality development under good governance and international law, climate change, inequality, and the role of multilateral development banks such as AIIB. Let me say that I could have selected many other themes, but in the interest of time, I focus on those 3. First, climate. A growing body of international environmental governance approaches codified under international treaties and the so-called soft law. International environmental law plays a crucial role in promoting sustainable development. It establishes principles and guidelines for the conservation and sustainable use of natural resources, the protection of our ecosystems, and the prevention of environmental degradation. Good governance practices such as effective environmental management and regulation are essential for achieving high-quality development that this is environmentally sustainable. Climate change and inequality are 2 interconnected global challenges that have significant implications for society and the environment, and they know no borders. Climate change refers to long-term shifts in weather patterns and temperatures primarily caused by human activities such as burning fossil fuel and deforestation. Inequality, on the other hand, refers to the unequal distribution of resources, opportunities, and power among individuals and communities. There are several ways in which climate change exacerbates existing inequalities. First one, disproportionate impact. Climate change affects different regions and communities in a very unequal way. Vulnerable populations such as low-income communities, indigenous peoples, and marginalized groups often bear the brunt of climate-related disasters, including extreme weather events, sea level rise, and food insecurity. Access to resources. Climate change can exacerbate resource scarcity, such as water and arable land, leading to competition and conflicts. Those who are already disadvantaged may face further challenges in accessing essential resources and existing inequalities. Economic disparities. Climate change can have adverse impact on economies, particularly in developing countries, heavily reliant on agriculture and natural resources. This can lead to economic downturns, job losses, and increased poverty, further widening the gap between the rich and the poor. Finally, health impacts. Climate change can have severe health consequences, including increased heat-related illnesses, spread of infectious diseases, and mental health issues. Vulnerable populations with limited access to health care and resources are more susceptible to these health risks, deepening existing health inequalities. Addressing climate change and inequalities require a comprehensive and integrated approach, and this includes mitigation efforts, reducing greenhouse gas emissions through transitioning to renewable energy sources, promoting energy efficiency, and adopting sustainable practices that can help mitigate climate change and the impacts that derives from that. This can also create job opportunities and promote economic growth. The very rapid growth that we see, for example, in China and solar panel is a testimony of that, adaptation. Adaptation measures. Implementing strategies to adapt to the changing climate, such as building resilient infrastructure, that is the business of AIIB, improving disaster preparedness, and enhancing social safety nets. Social justice and equity. Prioritizing social justice and equity in climate action is crucial. This involves ensuring the participation and representation of marginalized communities in the decision-making process, addressing historical injustices, and providing support and resources to those most affected by climate change. Finally, international cooperation. Climate change is a global issue, not a local one. It affects local, but it is a global issue. That requires collective actions. International cooperation through agreements like the Paris Agreement can facilitate collaboration, knowledge sharing, and financial support to address climate change and reduce inequalities. By addressing climate change and inequalities altogether, we can work towards a more sustainable and equitable future for all. Now, I'd like to address the interplay between inequality and international law. Inequality is a pressing global issue that affects individuals, communities, and nations, and we can see that rapid deterioration in inequality after the pandemic that we all suffered between 20 and 23. Inequality is a pressing issue. It refers to unequal distribution of resources, opportunities, and power among different groups of people. International law plays a crucial role in addressing and mitigating inequality by promoting principles of equality, non-discrimination, and social justice. International human rights law is a fundamental framework for addressing inequality. It recognizes the inherent dignity and equal rights of all individuals, regardless of their race, gender, nationality, or any other characteristics. Human rights treaties and conventions establish legal obligations for states to ensure equal treatment and non-discrimination. Furthermore, international labor law aims to protect workers' rights and promote fair and decent working conditions. It addresses issues such as discrimination, forced labor, child labor, and unequal pay. By establishing standards and guidelines for labor practices, public international law seeks to reduce inequality in the workplace and promote social justice. I also like to make a reference to international trade. International trade law has implications for inequality. While trade can contribute to economic growth and development, it can also exacerbate existing inequalities if not properly regulated. International trade agreements aim to promote fair and equitable trade practices, ensuring that all countries, particularly developing nations, have equal opportunities to participate in the global trade. By reducing trade barriers and promoting inclusive trade policies, international law seeks to address economic inequalities and promote balanced development. On this point, I can only lament the sorry state of WTO's dispute resolution mechanism, and only hope that this situation is addressed and solved soon. Additionally, international environmental law recognizes the disproportionate impact of environmental degradation on marginalized communities and vulnerable groups. It emphasizes the principle of environmental justice, which seeks to ensure that all individuals, regardless of their socioeconomic status, have equal access to clean and a healthy environment. By addressing environmental inequalities and promoting sustainable development, international law contributes to reducing disparities and promoting social equity. However, it is important to acknowledge that international law alone cannot fully address the issues of inequality. It requires the commitment and cooperation of states, civil society organizations, and individuals to implement and enforce these legal frameworks effectively. Efforts to combat inequality should also include comprehensive social and economic policies, poverty reduction strategies, and inclusive governance practices. Inequality is a complex and multifaceted issue that requires a comprehensive approach. International law provides a crucial framework for addressing and mitigating inequality by promoting principles of equality, non-discrimination, and social justice. By upholding human rights, labor rights, fair trade practices, and environmental justice, international law contributes to reducing disparities and promoting a more equitable and inclusive world. However, sustained efforts and collaboration at all levels are necessary to effectively tackle inequality and create a more justice and equal society. Now, throughout this presentation, I have presented several challenges. I'd like now to turn to the world and the role of multilateral development bank in addressing the governance issues discussed today. Multilateral development banks play a crucial role in developing and promoting good governance practice in their member countries. Good governance is essential for sustainable development as it ensures transparency, accountability, and effective decision-making. MDBs, as we call, such as the World Bank, the Asian Development Bank, African Development Bank, and the institution I represent, AIIB, have recognized the importance of good governance and have integrated it in its operations and policies. MDBs provide a financial resources, technical assistance to member countries for development projects and programs. To access these funds, countries are often required to meet certain governance criteria. MDBs assess the governance practices of countries and also companies, including transparency, accountability, and anti-corruption measures before approving projects. This incentivizes countries to improve their governance systems and promote the adoption of good governance practices. In addition, multilateral development banks actively engage in policy dialogue and capacity building activities with member countries. They provide technical expertise and guidance on various governance issues, such as public financial management, procurement, and regulatory frameworks. Through these interactions, MDBs can help countries develop and implement effective governance systems. Furthermore, MDBs support the development of legal and regulatory frameworks to promote that good governance. They assist countries in drafting and implementing laws and regulations that enhance transparency, combat corruption, and protect the rights of citizens. MDBs also provide support for the establishment and strengthening of institutions responsible for promoting good governance, such as anti-corruption commissions and ombudsman offices. MDBs also play a role in promoting regional and international cooperation on governance issues. They facilitate knowledge sharing and exchange of best practices among members, enabling them to learn from each other's experience. MDBs also collaborate with other international organizations such as the United Nations and regional development banks. Moreover, MDBs have their own governance standards and policies that guide their operations. They have established principles and guidelines for transparency and accountability and integrity in their own activities. Multilateral development banks play a significant role in developing and promoting good governance through their financial support, policy dialogue, and capacity building. They also contribute to the strengthening of governance institutions and the adoption of practices. By integrating good governance in their operations and policy, they promote the accountability that is needed for the projects they finance. While international law and international organizations cannot provide or dictate specific governance models, it provides a foundation of principles and standards that can guide states towards good governance. By adhering to international legal obligations, governments can promote transparency and accountability and sustainable development, ultimately contributing to the well-being of their citizens and the international community. Ladies and gentlemen, in conclusion, promoting good governance and high-quality development under international law is crucial for the sustainable growth and prosperity of nations. International law provides a legal framework for promoting transparency and accountability. It also establishes standards and guidelines for sustainable and inclusive development, ensuring that economic, social, and environmental dimensions are considered. By adhering to international law, states can foster an environment conducive to good governance and high-quality development, ultimately benefiting their citizens and global community. Again, let me thank the Hong Kong Department of Justice for their kind invitation and the audience for its patience, as I have attempted, hopefully somewhat successfully, to weave distinct but complementary issues under the framework of good governance. Thank you very much.
Thank you very much, Mr. Lineot, for your wonderful keynote remarks. Please kindly be seated. Thank you very much. So now we're going to proceed to our first panel discussions on interconnectivity of rules, the role of Hong Kong in the country's institutional opening up. So I would like to invite the moderator and panelists to come up on stage for these sessions, and please kindly be seated as indicated on the screen. So first, we'll be having our moderator, Mr. Roden Manlong Tong, President of the Law Society of Hong Kong, and our panelists including Dr. Anthony Keynote, SC, JP, co-chairman of the Asian Academy of International Law. Ms. Peggy Au Yang Wai Yu, Principal Government Counsel of the Legal Enhancement and Development Office, Department of Justice, the Government of the Hong Kong SAR, and also Mr. Philip Yang Liang Yi, Honorary Chairperson of the Hong Kong International Arbitration Center. So just a gentle reminder that there will be a Q&A sessions after the panel discussion. So if you have any questions for our moderator and panelists, please scan a QR code on the screen, on your table, or around this hall. And our moderator and panelists will address them accordingly. And now without any further ado, I'm going to pass over the stage to Mr. Tong.
Good morning, everyone. First of all, I want to welcome everyone to this first panel of this session today. The topic is interconnectivity of rules, the role of Hong Kong in the country's institutional opening up. I'm very happy to join by a distinguished panel. In the order of presentation, I would first of all introduce Dr. Anthony Nell, SC. He's the co-chairman of the Asian Academy of International Law. Dr. Nell is a senior member of the Hong Kong Bar Association, specializing in international litigation, arbitration, and financial regulatory matters. Dr. Nell has served on a number of public office. He was a member of the Hong Kong Stock Exchange Council and its listing committee, and chaired its disciplinary committee and debt securities group, and was co-chairman of the legal committee of the Hong Kong and China listing working group. He was also the chairman of the Hong Kong Securities and Futures Commission. The second speaker is Ms. Peggy Au Yang. Peggy is the current Principal Government Counsel in the Legal Enhancement and Development Office under the Secretary for Justice Office. She assists in taking forward the initiatives on strengthening the rule of law education, as well as the promotion and enhancement of the legal cooperation between Hong Kong and the mainland, in particular in relation to the construction of the Kong-Tong Hong Kong-Macau Greater Bay Area. Last, but certainly not least, we have Mr. Philip Yan. Philip has been a full-time international commercial arbitrator for over 30 years. He is the honorary chairperson of the Hong Kong International Arbitration Center. He is the member of the expert committee of China International Commercial Court of the Supreme People's Court of China. He also chairs the Shanghai International Arbitration Academy. Returning to the topic today, the role of Hong Kong in the country's institutional opening up. I would like to give a brief highlight of the resolution of the CPC Committee on further deepening reform comprehensively to advance Chinese modernization, which was adopted in the third plenary session of the CPC Central Committee in July this year. The resolution outlined over 300 major reform measures with a focus on strengthening the rule of law in China, particularly in foreign-related affairs. The three contents of the resolutions related to Hong Kong include to reinforce and enhance Hong Kong's status as an international financial, shipping, and trade center, to support Hong Kong in building itself into an international hub for high-caliber talent, and to strengthen the work on the development of the Greater Bay Area, to enhance the systems related to lawyers, notarizations, arbitrations, and mediation, and to improve the arbitration and mediation system. With these three key elements in mind, I will now invite Dr. Anthony Lau, SC, who will give us an overview on the practice and experience on Hong Kong in connecting with high-standard international commercial and trade rules. Over to you, Dr. Lee.
Okay. Well, good morning, ladies and gentlemen, and it's very nice to see our good friends here, particularly Commissioner Tsui, Commissioner Fong, and Dr. Sun this morning. Now, I've been asked to talk about high standard international commercial and trade rules. Let me start with some history. Well, Hong Kong has always been a free port since 1841 when it first started. No custom duties were collected, although the Qing dynasty, in fact, had a customs collection station in Kowloon before it became part of Hong Kong in 1865. But after 1865, the treaty of UK treaty, which we consider to be unequal, was signed, and the Kowloon was then ceded. But then Kowloon, the customs station then moved to Kowloon Bay, which is not part of Kowloon at the time, and is next to the walled city, which was known then. But then the new territories was then leased to the British government in 1898. But then under the treaty, the customs station was still retained in Kowloon Bay. But unfortunately, Britain didn't really like that. And the Qing dynasty was very weak at the time. And the British government then sent troops into Kowloon City and then basically asked the customs station and the officials of Qing dynasty to leave, and they did leave. I gave the year 1905 by memory, but actually I fact-checked that as wrong. It's actually 1899, 1 year after the lease. In fact, so there was not a lot of patience on the part of the British government at the time. But since then, Hong Kong, since 1899, zero custom duties. We've always been a free port. Up to today, we are a free port. Now, but Hong Kong, of course, after the Second World War, became a very different creature. And Hong Kong has been the beneficiary of the international law and the international institutions which was created after the Second World War. That, of course, includes the UN, the World Trade Organization, the World Bank, the IMF, and so on and so forth. But in terms of trade, the most important agreement which Hong Kong benefited from was the General Agreement on Trade and Tariffs, which was the predecessor of the WTO. In fact, the Geneva meeting, which created the GATT, could not agree on setting up a WTO, so they decided on having an international convention. But that convention was very, very important for the growth of international trade. And you can see the statistics. Actually, so many tariffs were actually repealed really from the time of 1947 upwards, and really during the period of international trade all the way up to the end of the 20th century. In the beginning of the 21st century, a lot of tariffs were actually repealed. And we are now in a world basically with much, much less tariffs. There were some tariffs going on, but nonetheless, the tariffs did not destroy international trade. One of the important things that during the time of the early 50s up to now, Hong Kong experienced a tremendous growth in trade. One of the things that really created Hong Kong as an important export place was actually the US embargo when the Korean War started. The US embargo started in 1951 and did not end until 1970, actually, after the Nixon visit to China. So there's many, many years. Because of that, Hong Kong became a very, very important re-export place from other places into mainland China. And up to today, in fact, re-export from Hong Kong to the mainland represents more than 50% of the trade, of export trade in Hong Kong. In 2023, the export trade in Hong Kong was about 680 billion in US dollar terms. More than 52% of that is actually re-export from Hong Kong into mainland China. And only less than 49% actually are exports from Hong Kong to other countries. Now, the interesting thing about the exports to that is that during the 50s and the 60s and the 70s, Hong Kong became a very important light industry center. We were making things in Hong Kong, and we were exporting the things that we were making. Particularly, Hong Kong was making a lot of clothing, a lot of textiles. Because of that, Hong Kong, in fact, had to negotiate under an exception to the General Agreement on Trade and Tariffs called a multi-fiber agreement, which actually gave every country a set of quotas for export of clothing to developed countries. And Hong Kong became very adept in negotiating these quotas and operating these quotas. The important thing about these quotas is this, is that you have to ensure that whatever is made in Hong Kong, is not made in other countries. And therefore, these rules are called rules of origin, which were very important and which lays the groundwork, in fact, for the next phase of development. We were so good at the MFA that later on, when the MFA was gone, and Hong Kong became a member of the GATT in 1986, the Hong Kong, of course, became a independent customs territory. Because of that, we joined the General Agreement on Trade and Tariffs in 1986, 1 year after the Sino-British joint declaration was signed. And that was basically the deal that China and Britain had, that Hong Kong, as an independent territory, can independently join the General Agreement on Trade and Tariffs in 1986. And because of that, Hong Kong became a founding member of the World Trade Organization when it was formed in 1995. So again, Hong Kong has a place in the international trading order. But that place, in fact, was really, I think, informed as well as, I think, assisted by the history that we had from the 1950s right all the way to 1995. The important thing is this. By 1995, Hong Kong is no longer a place that makes things. By 1995, Hong Kong's manufacturing industry was dwindling in 1995. And by now, today, let's look at today, from 1995, today, less than 1% of the goods that Hong Kong exports is actually made in Hong Kong. 99% are re-exports. Now that is well, you say that, well, in that case, what's made in Hong Kong? That's the question. Now, that's the question that, in fact, is asked, in fact, from the 80s onwards. Because from the 80s onwards, the supply chain of the world became global. Because you have one thing. Let's look at Apple, for example. Apple, that iPhone, is actually, a lot of that is made in China, but part of it is made in the USA. Some of the chips are made in the USA. It is manufactured in China. Some of the parts are made in India and so on. They get all sort of made into a phone by Foxconn in China. The question is, where is it made? Because many parts are made in various bits of the world. So which is why the WTO devised the rules of origin. Now, these rules of origin, in fact, say this, is that in terms of a widget, something like this, the value of that is not just in the way it is made. The value of that comes from the intellectual property that goes into it, comes from the quality assurance that goes into the manufacturing, comes with, in fact, the way that it is operated through the global supply chain, and so on. Which is why a product, in fact, have rules of origin. And the rules of origin essentially say that in any place that has between 30 to 50% of the value of a product, that place can claim to be the place of origin of that product. Which is why Apple can claim, in fact, under the rules of origin, that Apple is actually a US product, because it has a lot of. Now, Hong Kong, because of that, apply IP, intellectual property, in a lot of the goods that we have made in the mainland. They go into the quality assurance, they manage the goods. In fact, the branding of the goods essentially is a Hong Kong branding. As a result of that, Hong Kong, in fact, have its exports at the moment, 350 billion of its exports are still considered, in fact, Hong Kong exports. In fact, the reason is that more than 30% of that comes from Hong Kong. More than 30% of that comes from Hong Kong added value. The Hong Kong added value means that, the IP comes from Hong Kong, the design comes from Hong Kong, the knowledge that makes the product comes from Hong Kong, the supply chain management comes from Hong Kong, and so on and so forth. That's why Hong Kong still retains an important position in the international trade arena. Now, because of that, Hong Kong has been very much part of the rulemaking in the WTO. In fact, the original staff, executive staff at the WTO, were Hong Kong trade officers, actually. And also, Hong Kong, of course, once, at some time, in fact, chaired the Executive Council of the WTO because of its membership. And of course, when China, in fact, acceded to the WTO, Hong Kong gave a great deal of help to the Commerce Department in order to do that. So again, Hong Kong has a lot of prime mover ability in terms of that. The other thing, moving away from the international trade law area, you have international customs, for example. Now, the international customs that we use in international trade are, say, Incoterms for trade financing in terms of the uniform customs of practice and so on. Now, all of these come from the International Chamber of Commerce. Now, Hong Kong is very, very much part of the rulemaking body of the International Chamber of Commerce. And in fact, at one time, the chairmanship of the International Chamber of Commerce was in Hong Kong. Dr. Victor Fung, in fact, was the chairman of the International Chamber of Commerce. And also the ICC, which is the International Chamber of Commerce, also is one of the most important arbitration courts in the world. It's the International Arbitration Court. And my co-chair, Ms. Teresa Chang, was formerly the deputy president of the International Court. So again, Hong Kong has a lot of say in these bodies. Not only that, but in terms of aviation and shipping, Hong Kong, of course, has its own register. But prior to that, Hong Kong has a great deal, even then, before 1997, Hong Kong has a great deal of autonomy in terms of that. Hong Kong negotiates its own air transport. This is air traffic agreements around the world. This is, Cathay Pacific going to London, how many trips, and the BA coming to Hong Kong, and so on and so forth, all these trips and so on. Hong Kong has been traditionally negotiating that by itself, in fact, since, 1986. Prior to that, in fact, Hong Kong has to negotiate through the British government. So I was a member of the administration up to 1980. I was at one stage involved in that, and Whitehall was very bad to us. And our financial secretary pushed back all the time. But nonetheless, since 1986, after the signing of the Sino-British Agreement, Hong Kong essentially got autonomy in air traffic agreements. Now, in addition to that, Hong Kong also has been very active in the international shipping arena. Now, BIMCO, which is the Baltic International Maritime Organization, was previously the Baltic Exchange, very important shipping conglomerate association around the world. In fact, the Baltic Exchange even started before the 19th century, right up to the Middle Ages with the Hanseatic Reed. Hong Kong now chairs BIMCO. In fact, one of the shipping companies in Hong Kong, the chairman chairs BIMCO, which is why, again, we are very, very much into the international trade rules. Now, let's come to the present day. The present day, we have gone one up in the present day. The reason why we've gone one up is that under the basic law, China has given Hong Kong its own shipping and aircraft register. Now, that actually is very, very important in terms of all kinds of financing around the world, because title is actually registered in Hong Kong. The second thing is that under Chapter 7 of the Basic Law, Hong Kong has much autonomy in commercial and trade affairs, and therefore very much involved in the international trade making. And even then, if we were not part of the organization in our own right, as Commissioner Trade this morning told you, that Hong Kong always attends as part of the PRC delegation and makes a true and important contribution in that respect. And which is why Hong Kong is the beneficiary of a lot of the World Trade Organization protocols, such as TRIPS, which is the protection of IP rights, TRIMS, which is a protection of investment, the TFA, which is a trade facilitation agreement. Hong Kong has one of the very best trade facilitation systems and IT systems in Hong Kong, in the world. And this is tied up with trade financing. And Hong Kong was very much part, through Dr. Victor Fung's efforts in the ICC's international efforts in tying up a supply chain, tying up trade facilitation and trade financing, all three tied up in one system. And that is what the ICC has done, again, through Hong Kong. Dr. Fung himself has been very, very much involved in that. If you were to invite him here today, he would last the whole day. He can talk about this the whole day. Now, so therefore, really, Hong Kong plays a very, very important part in international trade. And because of that, Hong Kong was able to really parlay a lot of its experience into its free trade agreements. Hong Kong has now many free trade agreements. Now, Alberto, my friend, just now said to you he's very, very sad about the dispute resolution system in the WTO. That is true, but the WTO rules are still very useful, and the ethos of those rules are now applied through many of the free trade agreements around the world. So that has what I would call a kind of a moral leadership, which is important, which actually infuses all the free trade agreements. And Hong Kong has been very, very much part of that. So we have many free trade agreements. The most important one, of course, is the one with ASEAN, and of course, with RCEP now coming up. So again, our sovereign country is helping us to join the RCEP, which will be important. So again, this is such an important area. Now, just one final word, which is that all of this, of course, is trade and commerce, but it also feeds into money. Basically, the financial aspect of trade is just as important. Now, I have no time to deal with that, but again, we have exactly the same, if not more, in fact, say in the international rulemaking and international intercourse in finance. The most important bit of this, of course, is that Hong Kong is very much part of the, through our central bank, part of the Financial Stability Board, which is part of the G20, an important organization. So we take part in a lot of the G20 discussions in terms of finance. Again, Hong Kong is at the forefront, and in fact, the BIS uses Hong Kong as their base for digital money in the world. And in the future will be digital money, and it starts from Hong Kong. Thank you.
Thank you, Dr. Liu, for an excellent overview on the history and the present-day interaction with the high-standard international commercial and trade rules. So may I now invite our next speaker, Ms. Peggy Aouyang. Peggy will tell us about the progress and prospects on the linkage of rules in the Greater Bay Area. Over to you, Peggy.
Thank you, Roden, for the kind introduction. And Commissioner Choi, Deputy Commissioner Fong, Dr. Sun, esteemed guests, ladies and gentlemen, good morning. It gives me great pleasure to join this very distinguished panel, Dr. Liu and Mr. Philip Yan, both very experienced legal practitioners in Hong Kong. And I'm very privileged to be with you today. The theme of this panel is connectivity of rules, the role of Hong Kong in contributing to the country's institutional opening up. On this, I would like to share with you the progress and the prospects of the linkage rules in the Greater Bay Area and how such connectivity would contribute to our country's institutional opening up. The term GBA, this reference, may be of very familiar to many of you, but it would still be worthwhile for me to perhaps just highlight some of the fundamentals. So, GBA comprises 2 special administrative regions of Hong Kong and Macau, and 9 cities in the Guangdong province, including Guangzhou, Shenzhen, Foshan, Dongguan, just to name 4 of them. On the extensive potential of the GBA, perhaps I will let the facts to speak to you. First of all, in terms of land area, the GBA is about 60% of Portugal and 43% of Greece. Secondly, in terms of population, GBA's total population is bigger than that of the UK, Italy, or South Africa. Turning to the money terms, GDP, GBA would rank ahead of Russia, South Korea, Spain, or Australia. If one is to compare the GDP's growth with other Bay Areas in the world, GBA enjoyed around 4 to 5% growth last year. San Francisco Bay Area around 3 or 4%. In Tokyo Bay Area, 1.5. What is more important is that the GBA has a very unique legal landscape. Within one country, we have 2 systems and 3 jurisdictions, the mainland, Hong Kong, and Macau. In literal terms, the GBA is home to 3 legal systems. And I don't think this feature could be found in anywhere else in the world or any other Bay Areas. Therefore, against such legal landscape, which is so unique, and such enormous growth potential, what has the Department of Justice been doing to contribute to its development? In response to this 1, 2, 3 structural landscape, we have underpinned a guiding principle of 3, 2, 1 in our action plan on the construction of rule of law promulgated by the Department of Justice in April this year. We aim to promote 3 interfaces, namely the interfaces of mechanisms, regulatory frameworks, and legal talents, in order to foster 2 connects, the connectivity of hardware and software in the construction of rule of law. And our eventual goal is to construct 1 GBA, strong and prosperous. While it is always good to have catchy phrases 1, 2, 3, or 3, 2, 1, we never forget to be pragmatic in transforming them into effective policy measures which are helpful to the legal and business sectors, the whole GBA, the country, and beyond. Allow me to focus on 2 aspects showing the latest development in the linkage of rules in the GBA. Firstly, the adoption of Hong Kong law and Hong Kong as the arbitration seat. Hong Kong is the only common law jurisdiction in China, and we have profound rule of law infrastructure. Our laws and dispute resolution services are highly compatible with those of the world. Investors, local and abroad, are often very familiar with our laws, rules, and services. We note that under the mainland law, the default legal position is that unless the contractual matter has met the requisite requirement of foreign elements, the matter would generally have to be subject to mainland law, and the relevant disputes be resolved before mainland courts or by the mainland arbitral institutions. At the moment, there is some flexibility for enterprises which are Hong Kong invested, but register in certain areas in the GBA to adopt Hong Kong law as the applicable law or choose Hong Kong as the arbitration seat. Such measures have a confined scope of application, the former in Shanghai, Shenzhen, the latter in the pilot free trade zones in the mainland. Let's first take a look at the implementation of the first measure of Hong Kong as the applicable law in the Shanghai court in Shenzhen. It's fair to say that the Shanghai court is one of the most forward-looking basic people's court in the mainland, and we're most grateful for its great contribution as the experimental platform in the past years. The Shanghai court has been the basic people's court handling the highest number of foreign-related or Hong Kong or Macau or Taiwan-related civil and commercial cases in recent years. Around 30% of its cases are such cases, and among them, close to 60% are Hong Kong-related. And what is more, it is also the mainland court which has applied the Hong Kong law in the highest numbers of cases, amounting to a cumulative of over 130. In applying Hong Kong or foreign law in over 50 cases, the Shanghai court has engaged experts to assist in the proof of Hong Kong or foreign law, and in some cases, such experts have testified before the mainland courts. If you happen to like to hear more on this subject, I will invite you to join our Thursday morning session, in which there will be a thematic session sharing by experienced mainland judge, Hong Kong lawyers, and mainland lawyers who have first-hand experience on the topic. Going forward, our department is seeking to expand the scope of measures to cover more areas or other cities in the GBA. In this regard, we have very good news to share with you. Just last month, we have welcomed the amendments to the CEPA agreement on trade in services, in which the 2 measures are added as facilitation measures for Hong Kong enterprises. First of all, Hong Kong invested enterprises registered in the pilot areas of the GBA may adopt Hong Kong law as the applicable law in their contracts, or Macau law. Secondly, Hong Kong invested enterprises registered in the 9 mainland GBA cities may choose Hong Kong or Macau as the seat of arbitration. The expansion of these measures will facilitate the internationalization of the business environment of the GBA, and more importantly, encourage mainland enterprises to use Hong Kong as the springboard to expand to overseas, and foreign investors to use Hong Kong as the gateway to the mainland. In the long run, we are seeing that Hong Kong's common law system will be contributing more in bridging the gaps and facilitating both onshore and offshore investments. This would be nothing but a strong testimony of how Hong Kong's unique advantages as a common law jurisdiction would contribute to the national high-quality development. Now let me turn to the second aspect of linkage rules in the GBA. It is the GBA mediation platform, a concerted effort of the legal departments of the Guangdong, Macau, and Hong Kong. Currently, 3 sets of unified rules or standards on mediation are in place in the GBA. The first set unifies the qualification requirements for GBA mediator accreditation. The second provides for a common professional code of conduct for mediators. And the last one is the model rules for mediation of cross-boundary disputes in the GBA. So what is Hong Kong's role in this? Hong Kong has proudly contributed to their drafting, in the process of which Hong Kong could be said to have exported our best practice and our experience. Let's consider the GBA mediator accreditation standards. When they were formulated, the prevailing accreditation requirements adopted by our homegrown Hong Kong Mediation Accreditation Association have been taken on board. In specific terms, work experience and case experience requirements, being standards adopted in Hong Kong, are featured in the GBA standards. The Code of Conduct and Model Mediation rules also feature various best practices in Hong Kong's mediation regime. For example, the Code of Conduct provides for the role of mediators in facilitating the parties in reaching consensus, and this is consistent with the primary practice of facilitative instead of evaluative mediation skills in Hong Kong. Both sets of rules prescribe for the use of caucus sessions as well, which are the procedures of holding respective and confidential meetings just between the mediator and each of the parties. This procedure is commonly adopted in Hong Kong's mediations and proved to be effective in facilitating candid dialogues so that the mediator could fully digest each of the parties' underlying concerns and hence help finding common grounds. While unification would be most helpful, the GBA mediation platform has at the same time taken into account the circumstances and operational needs of the 3 of the jurisdictions. For example, the relevant model rules would not prohibit a mediator, upon consent by the parties and where appropriate, to help evaluate the case and suggest options proactively. These specific roles, though not commonly adopted in Hong Kong's facilitative mediation model, would in fact pose no difficulties to Hong Kong's mediators, especially those who are legally trained. So looking ahead, having witnessed the very positive experience in the GBA mediation platform, what would be our next steps? I'll highlight 5 directions. Firstly, we are seeking to formulate a panel of GBA mediators by the end of this year. Secondly, we are turning to arbitration and working closely towards a set of common standards for setting up a panel of GBA arbitrators as well. With good rules in place, we need good talents to make good use of them. Hence, thirdly, we are supporting the latest initiatives of allowing access to civil and commercial cases filed in specific mainland courts in the GBA and the resolution of these cases through mediation by Hong Kong mediators. We warmly welcome such direct deployment of our legal talents by the mainland courts. And fourthly, still on talents, we attach great importance in building up a sustainable role and sustainable force of legal talents rooted in the GBA, serving the whole country and venturing abroad. The GBA enjoys a distinctive advantage of the presence channeling the interface of rules and practice within the GBA. The DOJ is advocating for a more structured frame building of GBA lawyers, facilitating them to contribute more to the country's continuing opening. Going further, we are establishing a new institution, the Hong Kong International Legal Talent Training Academy, and you're most welcome to join us on Friday. This academy will organize practical legal courses, nurturing legal talents, and of course, international commercial arbitration and international commercial mediation will certainly be one of the subjects that the academy will touch upon. And lastly, bearing in mind the significance of affecting a mindset that embraces reforms and change, as specified by the Commissioner in this morning's opening address, we endeavor to be innovative in the construction of the GBA as well. Apart from soft laws, like model mediation rules or model mediation arbitration laws, we would like to explore the need for and the feasibility of making unified laws and regulations in the GBA. So a topic like the common set of contract laws we work on for our further studies. We will certainly welcome to hear more from you, the stakeholders and experts too. To conclude, our work on connectivity of rules and talents in the GBA is always a work in progress, as it is a long-term strategy. At the same time, we're determined to bring more and more deliverables in the not-too-distant future. So, I'd like to wind up by sharing some thoughts on what principles will be relevant to us in the days to come. Let me start with the G in GBA. It stands for groundbreaking. I think we should not be afraid to do so, especially that construction of GBA is the most innovative of all. For the B, I would say broad-minded. We should always be conscious of the bigger role GBA plays in the country's development and the potential it could bring on and beyond the country. And lastly, I would say agility. It is essential to be agile and adapt swiftly to the rapidly changing global landscape so that we could be proactive in leading the development in and out of the GBA. On this note, and with the groundbreaking spirit, a broad mind and an agile approach, I would like to work with you all in the construction of our prosperous GBA, unlocking its immense potential and contributing more to the national development and beyond. Thank you.
Thank you so much, Peggy, for sharing with us what the Department of Justice's action plan on the construction of the rule of law in the Greater Bay Area. So DOJ has really done a lot. So now, certainly not least, may I now invite Mr. Philip Yant to tell us a bit more on the Hong Kong's international arbitration regime in providing unique service to the country's institutional opening up. Over to you, Philip.
Okay. Ladies and gentlemen, thank you for inviting me to join this session. I would like to share with you, as a practitioner in arbitration, and the topic is Hong Kong international arbitration regime in providing the unique service to the country, institutional opening up. So I should turn to the first slide. Now, these are well-known mainland China policies and aspirations. I don't think I have to read them out, and it's all familiar to all of you. For example, the need to further strengthen international trade, one belt, one road, and play by the international laws and rules. And there is the omission of inadequate expertise in the mainland capable of handling international arbitration cases, which comes from the central government. And then, of course, it is important that China is already the second largest economy. Commissioner Choi has mentioned 18% of GDP. And I can say China, when it comes to international trade and shipping, maritime, it is in fact number one in the world. So that means a lot of contracts, a lot of disputes to resolve and so forth. This, I would say, all points to the importance of Hong Kong, which is the only common law jurisdiction in China. The uniqueness of Hong Kong, firstly, Hong Kong is the common law jurisdiction, and English law or common law is the de facto international law to international trade and commerce. Nowadays, in international trade and commerce, we look for guidance, we look for authority, we all look at common law. We don't look at any other law. And when I was young, more than 50 years ago, I still remember a time when I come across, for example, French or German standard form contract. I used to involve in standard form called Sino-Comex, French form, pointing to French law and so forth. Now, for the last 20, 30 years, I've never seen any other form other than English law form standard contracts. And Hong Kong, under one country, two system, we all know that Hong Kong follow the common law, follow English law. This has been reconfirmed again in the Hong Kong Court of Appeal case last year. Now, and Hong Kong is also a very important international arbitration hub in Asia. And remain receptive to the international commercial world. Historically, in fact, we are the first one in Asia. If you look at HKIAC, which I am the honorary chairman, we established ourselves in 1985 when globalization started. And SIEC, our nearest competitor in Asia, SIEC started 6 years later. Within that 6 years, I remember I went down to Singapore numerous times, 1 year at least 3 times, 2-3 times, just to teach arbitration. So we are having a head start in Asia in that sense. Of course, people can catch up, but the expertise remains in Hong Kong. That's important, some of the expertise. And Hong Kong has also built up a very comprehensive procedural law, case law, which is well known in the common law jurisdiction. It is often cited in English cases. I don't have the figures, but in Singapore, I come across a figure of 16%. In Singapore, court cases, when it comes to commerce and international arbitration, 16% of the cases, they rely or cited Hong Kong authorities. Now I come, after Hong Kong, I'm coming back to the difficulty China is facing to join the international world. Commerce and law. And that is China has insufficient people, an experienced legal profession, which I've already touched upon. China has spent a lot of money in the last 30, 40 years to train expertise. It seems China has been very successful with science and technology from the very clear result that we all can see. But when it comes to law, it hasn't worked out very well. So it seems that the previous way of education will have to be reviewed. But unfortunately, we have the geopolitical tension. That means some of the better ways of acquiring international law, especially private law, is getting more difficult. For example, to study abroad and so forth. Of course, like everything else, whether it is chips, whether it is AI or EV or rocket science, China has to be self-reliant. And I think when it comes to this area of international law and international arbitration, China will have to go the same route. Now I come. I'm sorry, I've moved a little too fast. I skipped one PPT. Yes. Those are some of the difficulties which China are facing. But I'm not going to touch too much of them. I just say that when it comes to international arbitration, China has a lot of thriving arbitral institutions, which we all know: CTAC, Beijing Arbitration Commission, Shenzhen Arbitration Commission, and so forth. And a lot of cases, a lot of arbitrators. But unfortunately, China arbitration law and practice is not an apple-to-apple comparison with international arbitration. The international arbitration that are being conducted in Hong Kong, Singapore, New York, London, or ICC. For example, which is very important, China has no known system of arbitration procedural law, because according to China's arbitration law, the administration of an arbitration is being delegated instead of going to the court, it has been delegated to the institution, to the different arbitral institution. And that, of course, by itself, it cannot establish a system of law, and no lessons can be learned from each other and so forth. And it is very difficult for foreign commercial parties to actually to feel safe or familiar to accept mainland arbitration. And that is the difficulty which is facing China. And go side by side with it, no matter how much experience you have practiced in China arbitration, they cannot actually grow international arbitrator. Now, I come to a very important point, which is currently being aware by some of the state enterprises in China, and that is the public policy. In China, the public policy of China, and of course UK, USA are becoming more adversarial and polarized, and the trend is not going to improve in the short term. Unfortunately, public policy and illegality is an unruly horse, as we all know that, and you never know which direction it is going. The list may get longer and longer until it can never end. So it will bring a lot of uncertainty, especially to medium or longer term commercial contracts. And as I said, China's state enterprises are starting to aware of it. Now, mainland China is the main user of English law and London arbitration, by far the main user of London maritime arbitration. Shipping arbitration is very important, and we all know the organization, which is called London Maritime Arbitrator Association, LMA. LMA rules, of course, has to be in English, but LMA rules has only one foreign language version, and that is Chinese. That means China users are very important to LMA. And for time to time, I've heard a figure of 50% of LMA cases came from China or China related. So that is the sort of figures of London arbitration. Now, why they use London English law and London arbitration? Of course, like everybody else in the world, confidence, and indeed London arbitration and English law has been doing very good services. And it also has to do with English law standard form contract, which I mentioned from the start. In Chinese domestic trade, they all use standard form contract. For example, shipping, they all use BIMCO contract. BIMCO contract, the default position is London. is London. And I have been the documentary committee vice chairman for 6 years, and in the documentary for over 35 years. So I know how the standard form contract has spread over the world when it comes to maritime and offshore industries. So a lot of standard contract, a lot of international trade, they use FNASPA standard form or phosphorus standard form. Even in China domestic trade, for those reasons, as they are not cautious or alerted to the problem of public policy, they continue to use it, and they are sucked into the English law and London arbitration, and will be sucked into the public policy and illegality issue. Now that is starting to alert the Chinese, the mainland Chinese state enterprises. Therefore, if you want to source another common law jurisdiction, an arbitration seat, Hong Kong has to fit the bill. Now, again, this slide, I don't have to mention too much, other than the second part. Hong Kong, as I said, is a well-known international arbitration system because of its procedural law, amongst other things. I just cite one case, Sagang. Justice Hambron, now Law Hambron, said some nice things, but he is not certainly the only judge who said something like this about Hong Kong, but I just use it as a quotation here. And you can see Hong Kong is no doubt geographically convenient. It is also a well-known and respected arbitration forum with a reputation for neutrality, not least because of its supervising courts. Now, so I come to the last PPT, and that is the Hong Kong may be very crucial to overcome mainland's difficulty when it comes to international law and international arbitration. The first part has to do with education, common law education, which I won't say too much about it because of the time. And the second part of it is that we welcome, Hong Kong welcome, and in fact I do see some very good people from mainland has actually coming to practice in Hong Kong, solicitor and barristers, and that is, I think, it's a very welcome thing to do. And now I come to the final part, which is in the commercial transactions. It will also facilitate mainland enterprises if they now start to focus themselves to depart. Even they continue to use the standard form contract, it doesn't matter. All is needed is to delete London arbitration and change it to Hong Kong. And Hong Kong is actually a very easy compromise for Chinese companies with foreign companies. They wouldn't like to go to mainland China's arbitral institution, but they can come to Hong Kong. And even with some of the Western countries, if Hong Kong is not acceptable to some of the Western countries, then perhaps a second compromise will be Singapore, at least to get away from the UK and US public policy problem. And finally, I'd like to say that just yesterday I've heard a friend of mine, which is the chairman of a Hong Kong Maritime Arbitration Group, has accepted an appointment which is between Russia and Turkey. An appointment as arbitrator, as a sole arbitrator between Russia and Turkey. So those are the cases that Hong Kong will start to attract, and I hope it will go that way, and that will be Hong Kong's future when it comes to international law and international arbitration. Thank you very much.
Thank you so much, Philip, for your invaluable insight on the country's opening up of the arbitration regime for the international commercial disputes. Now, I think we are a little bit over one on the time, but I do have some topical questions we'd like to ask the panelists. In particular, there's, as you know, that the US now is undergoing the US elections. So, Dr. Neil, so perhaps can you share with us what measure you think Hong Kong can take if the US government were to impose more sanctions to us, to Hong Kong?
Well, let me first of all say that Hong Kong, of course, is a free port. We don't impose tariffs of anybody, basically. And I don't think we're going to change that policy to start with. However, if you look at the US sanctions, on trade sanctions, forgetting the other sanctions on persons, because the person sanctions are a matter of sovereignty. It's a matter to be dealt with by our central government. Now, but as far as trade restrictions are concerned, we have, of course, a case whereby because of the so-called Hong Kong Democracy and Human Rights Act, Hong Kong is not considered to be as autonomous as it was in 1997 with the Hong Kong Policy Act. And that is the US interpretation, is not our interpretation, because autonomy is very clearly defined in the Basic Law. Now, but anyway, what has happened is that President Trump, before he ceased to be president, in fact, decided that Hong Kong does not have the autonomy, and therefore, Hong Kong-made goods, or Hong Kong goods which are exported from Hong Kong, made in China, should be labeled, in fact, made in China, not made in Hong Kong. Because prior to that, we do have this origination rules of 30%, in fact, could be said to be Hong Kong-oriented, Hong Kong-connected. We still can say made in Hong Kong. Now we have to label made in China. However, our people actually add one other word. It's made in China, but originating from Hong Kong. Now, that is important because the US Customs has not, in fact, denied the 30% rule. In other words, if we're able to prove with a certificate of origin that 30% of the value of that goods originated from Hong Kong, the US Customs still does not extract added tariffs on those. So the US has been relatively sort of rational in terms of that. There is the kind of saber-rattling, high political statements and so on and so forth. But in terms of actual on-the-ground work, we have not been denied the 30% rule. So basically, goods originating from Hong Kong, which is why last year, 2023, our exports to China is 34 billion. Whereas the imports from the US is 27 billion. So we still have a lot of trade between our two places. The US, apart from mainland, which takes up 52% of our exports, 300 odd billion is to mainland, the 34 billion US. So there is a lot of common interest between the US and Hong Kong in terms of trade. So they don't want to destroy that. In fact, prior to that, sometimes imports to Hong Kong is more than exports to US. But it sort of varies from year to year. So essentially what the US has done so far is to do a lot of sort of political statements. But in terms of actual work, they have not done to destroy their own position, which is why, despite the Democracy Act, the US did not, in fact, abrogate the air traffic agreements, did not abrogate the tax treaties, particularly did not abrogate, in fact, the Financial Account Tax Compliance Act, which is FATCA. All the banks in Hong Kong have to fill up FATCA forms in terms of US. So therefore, they're very, very careful in ensuring that, the common interests are still there, but allow, in fact, the politicians to say a lot of stuff.
Okay, thank you, Donna. So it looks like it's not too bad, right? Okay. So coming back to the Greater Bay Area. So Peggy, can you share with us what are the challenges in pursuing the interface of the rules and regulations in the Greater Bay Area?
Thank you, Roden, for the question. The challenges, yes, it is not an easy thing to have three legal systems in one country, and not an easy thing to make them work together to collaborate with each other so that each of its own distinctive advantages could excel and contribute to the country and beyond. First thing, substantive law. Substantively, the laws of the different jurisdictions differ. For example, we have different rules governing different aspects of civil and commercial, like marriages, divorce, and also the succession of property, so on and so forth. The second challenge is also could be seen in the way that legal procedures are conducted. For example, in Hong Kong, we practice the common law, and with the common law, we have the principle of adversarial system. It would be a party-led. So the parties will have say in how they conduct the cases. And they are, of course, in most high-end commercial cross-border cases, they will be assisted by our legal talents, the lawyers, barristers, and solicitors. In the mainland, it could be different. It's like more the court would have more role to the process. And what we are trying to overcome these challenges, we are building the gaps. Through our 3 connects, 2 connects, and a bridging of talents, we much like to help building a system that would facilitate the cross-border or cross-boundary resolution of disputes. So just to highlight one of the work in progress that would soon be promulgated is the service arrangements. So the system is again different. In Hong Kong, the parties serve the documents to the other side when they conduct the litigation. In the mainland, the court assists them. So it's again, you can see the challenges here. So we are trying to bridge the gaps. We are trying to give you all a version 2.0 service arrangement so that we would broaden up the scope of mode of services for Hong Kong parties to serve cross-boundary with the help of mainland courts. So we hope that with the concerted efforts in the room and beyond, with your intelligent and your contribution, we will bridge the gaps and overcome the challenges. And thank you once again.
Thank you, Becky. Thank you. So I'm sure, Becky, that with the joint efforts with the DOJ, the Law Society and the Bar Association and the Ministry of Foreign Affairs, we can overcome all the challenges. So last but certainly not least, Phillips. So one quick question. Any preference for the China-related contracts when it comes to dispute resolution? What's your view?
You mean, do you mean China preference?
Yep, or your preference.
My preference, of course, Hong Kong arbitration. But I think the Hong Kong arbitration, we used to be, actually, I don't mind. I sit a lot in London arbitration, especially before the COVID. And I'm not politically sensitive at all as a practitioner. But I understand in China, in fact, a state enterprise was concerned, and they actually talked to me, but they have already done that in an LNG, liquefied natural gas. They build a ship in China, and then they charter out and so forth. They start to feel worried about going to London arbitration with such a huge contract and so forth. And then they start to say, well, should we go Singapore or Hong Kong instead? And that was how it started, at least as far as my side of the knowledge is concerned. And now, of course, it become more, people talk about it now. And I understand people are still, of course, this type of knowledge you have to spread to a lot of commercial people. They are still using standard foreign contract. They are still receptive to London arbitration. And if they go to London arbitration, the problem is public policy. You'll be sucked into the public policy. You look at the New York Convention, it only, the New York Convention only concerned with regard to public policy in 2 places. One is the seat of the arbitration. The other one is the enforcement, the place of enforcement. Those two places will look at the public policy, and therefore it's not conducive to go to London anymore in that sense. So to me, it's logical to come to Hong Kong, or if some Western companies are concerned with Hong Kong, then Singapore is the second preference. That's how I think the trend is going. And we are talking about a huge market, China market, when it comes to GDP, economy, especially the activities in shipping and international trade. That means a lot of business is waiting to be tapped. Thank you.
Exactly. Thank you, Philip. And exactly, we are the top 3 IPO markets in the world anyway. Thank you very much, Philip. So I think our time is up. So can you join me in give a round of applause to our very distinguished panel? Thank you very much. Thank you.
Thank you very much, our moderator and panelists. Please remain seated. Please remain seated, and please look at our official photographer in the center for a group photos. All right, so please remain seated. Okay. 咁呢一張相我哋就一齊企起身影一張大合照啦，好嘛 ？Alright, so now our panelists and our moderator, please kindly look at our official photographer in the center for a good photo. Thank you very much for giving us a lot of your perspective and the role of Hong Kong in the country's institutional opening up. All right, so please remain on stage and please look at our official photographer for one more photo. Okay, a big round of applause for our moderator and panelists one more time. Thank you very much for your insightful sharing. So now, ladies and gentlemen, we are going to take a 15-minute break. So for those who are joining us on site, please enjoy the light refreshments right outside the hall. And for our online participants, please stay connected and I'll see you in 15 minutes. See you soon. Hello, ladies and gentlemen. The second panel discussions will begin shortly, so please kindly make your way towards your seats. Thank you very much. Also, a gentle reminder for all of our audience, please kindly turn your mobile phone into silent mode. 各位來賓，我哋第二場嘅專題研討呢，即將就會開始㗎啦。有請各位盡快就座，並且將你哋嘅手提電話調至靜音模式。各位來賓，我們第二場的專題研討馬上就會開始，有請各位盡快入座，並把你們的手提電話調至靜音模式。謝謝大家。 Ladies and gentlemen, so welcome back to our second panel discussions on rule of law as a risk management mechanism to safeguard Hong Kong's and national sustainable development. So already on stage, we have our moderator, Mr. Victor Dawes, BPSSC Chairman of the Hong Kong Bar Association, and he's joined by 3 panelists in this session, including Professor Shen Wade from Ko Guang School of Law, Shanghai Jiao Tong University, Professor Ian Grenfell-Cross, GBS-SC Honorary Professor, Faculty of Law, the University of Hong Kong. And also joining us online, we have Professor Liang Zheng, Vice Dean, Institute for AI International Governance, Tsinghua University. So same as the previous session, there will be a Q&A session after the panel discussion. So if you have any questions, please scan the QR code on the screen, on your table, or around this hall. And our moderator and speakers will address them accordingly. And now without any further ado, I'm going to pass over the stage to Mr. Dawes.
Thank you so much. Thank you. I was told that we are overrunning a bit, so I will, if you don't mind, get on with it because the speakers have been introduced and they are well known. So without further ado, can I invite an old friend of Hong Kong? I just got to know Professor Shan and find out that he worked in Hong Kong for 9 years before. So welcome back. And he will be talking about the interesting topic, new developments in financial sanctions and anti-sanctions. So Professor Shen, thank you very much. Thank you.
Thank you. 各位专家、各位嘉宾，早上好。非常荣幸参加这个活动。我听了前面一个发言的环节，我有2个感想。第一个是前面的环节主题都是比较商业友好的，所以我的选题呢是比较进攻性的，讲金融制裁和反制裁。第二个是前面的嘉宾，我发现演讲的时间都很长。 我被给的时间只有10分钟，这可能体现了1国2制。我尽可能的快简短一些。我的假设是在座的各位对金融制裁都有略微的了解。我主要讲3个问题，第一个是俄乌武装冲突以后，美国实施对俄罗斯的极限制裁，它的一些特征。 第二呢，俄罗斯在针对美国的金融制裁的背景下，一些反制裁的措施会给我们一些什么启发？第三个，在极限施压的背景下，制裁和反制裁呈现的拉锯的特征，以及对中国的一些启发。美国对俄的极限制裁，俄乌冲突以后，美国对俄罗斯联合了西方国家，对俄罗斯采取了极限施压。这个极限施压的特点是。 现在俄罗斯是全球被制裁最多的国家，一共有2万多起。大家可以在这张图看到，左边，这次美国对俄罗斯的制裁联合了西方国家30几个国家和地区，一些非传统的国家都加入了这个制裁体系，比如说瑞士，这些都是中立国，在以前是不可想象的。包括我国的台湾地区也加入这个制裁的行列，新加坡也加入了制裁的行列。 第二，在右边这张图非常明显，就是俄乌冲突以后，俄罗斯被制裁的数量极限的增长，增加到2万多起。在这之前，它并不是最大的被制裁国，伊朗是最大制裁国。这次制裁所谓极限施压，就是范围非常广。美国用了传统的制裁方式，比如说军事制裁，比如说政治制裁，但是出现了2个比较有趣的。 制裁现象，一个是金融制裁，这是今天讲的主要的。金融制裁是这次美国对俄罗斯制裁主要的制裁手段。另外一个就是商业制裁。商业制裁是什么意思呢？其实有很多美国的企业、欧盟的企业，并不是被美国或者欧盟要求对俄罗斯采取制裁措施的企业。比如说麦当劳、肯德基，他们跟战争没有关系。 跟高科技也没有关系，跟武装设备也没有关系，但是他们主动的要求撤出俄罗斯市场。 这样的企业有很多啊，很多欧洲的，比如说法国的奢侈品牌都撤出了俄罗斯的这个商业圈，所以呢，这个叫做商业制裁。商业制裁的一个目的就是这些企业想占领商业的制高点、道德的制高点，对俄罗斯进行极限的施压。在这些制裁当中，目前俄罗斯的所有的企业都在美国发动的制裁名单，一共有9个。在这9个制裁名单上面，俄罗斯企业都全部榜上有名。另外一个就是美国对俄罗斯制裁主要的是聚焦关键的行业，比如说是俄罗斯最有核心竞争力的行业，金融业、国防、电子、航天航空等等。在金融领域，金融制裁的极限的措施就是切断 SWIFT 系统，也就是说，在我们制裁领域的一个说法叫金融核弹。如果一个金融机构被踢出了 SWIFT 这个制裁体系的话，这个金融机构就没有办法从事美元的交易。这个 SWIFT 系统呢是总部设在比利时的，它并不是一个制裁的工具。如果被剔除的话呢，传统上并不属于是一种制裁或者反制裁的研究对象。但是 SWIFT 比较特别的是，它是金融机构从事美元交易必须进入的一个体系。如果它一个金融机构不在这个体系当中，它就无从进行美元的交易。另外一个，在这次金融制裁当中呈现出一个新的特点，就是俄罗斯和美国都进入到了加密资产行业。对反制裁的国家、对被制裁的国家和企业来说，反制裁的一个重要手段其实就是洗钱。对美国来说，遏制反制裁措施就是反洗钱。那么俄罗斯包括现在的朝鲜很多的企业，它通过加密资产和数字货币的方式来进行洗钱，逃避金融制裁。美国已经认为这是一个新的漏洞它需要阻截。美国金融制裁的体系是非常庞大和繁杂的，它一般来说有3个体系，一个呢是联邦法律这些联邦法律包括国际紧急经济权利法、国际紧急状态法等等。这个呢，授权参众两院可以采取一些措施。还有呢，就是行政命令。行政命令呢，是包括白宫做出的行政命令，包括白宫对中国发起的芯片的制裁，也是通过行政命令的方式来进行的。还有呢，就是财政部。财政部呢，是美国实施金融制裁最主要的行政当局。那么这里呢，罗列了一些美国对其他国家采取金融制裁的法律、行政命令、财政部的规章。美国的金融制裁执行机制呢，主要是通过财政部进行的。财政部下面的有一个办公室 OFAC 呢是进行执法的主要的执法部门。另外呢，美国的很多金融机构变相的成为了美国金融制裁执法当局的影子执法部门。他们在海外如果碰到了被美国金融制裁的交易对象，他们呢有义务直接报告给 OFAC 或者美国的财政部和美国的有关部门，所以呢，他们也是美国金融制裁的执法部门，或者叫影子执法部门。金融制裁和传统的制裁有很大的不同。传统制裁呢是贸易制裁、关税制裁，比如说中美贸易摩擦以后，前一个环节也有嘉宾提到，美国呢提升了对中国的很多产品的关税。那么这是贸易制裁，还有出口管制。但金融制裁呢，并不是传统的这个制裁手段，是在911以后，美国政府认为贸易制裁的成本非常大，贸易制裁对制裁国来说也是成本巨大的，他没有办法对自己的国内的跨国公司有所交代，所以呢，他认为阻挠被制裁对象，特别是恐怖主义组织的最佳方法是切断他们的财政来源，切断他们的资金来源。所以呢，发动了金融制裁。金融制裁的好处就是什么呢？就是它的网络非常密集，而且呢，对被制裁对象，特别是本拉登这种恐怖主义组织的制裁手段呢，是非常有效的，切断他们的资金来源。那么这些恐怖主义活动呢，就不能够蔓延开来。 但金融制裁对被金融制裁的国家和机构来说，就有非常大的挑战性。这个呢，就是在制裁领域叫做非对称性，它跟贸易的制裁完全不一样。贸易的制裁呢是对称性，你如果征收我25%的关税，我可以征收你25%的关税。但是金融制裁没有办法对被制裁国家采取反制裁的措施，原因是美元是世界上唯一一个世界储备货币，美元的支付体系。整个来说，对金融、对投资和对贸易的覆盖率是最大的。中国讲人民币国际化，到目前为止，在全球的贸易领域，它只占比增加到20%；在投资和金融领域，它的占比只有2.点几。所以从这个角度来说，被制裁的国家很难在金融制裁领域采取对称性的措施。所以金融制裁最大的特点就是非对称性。俄罗斯对美国的极限制裁和金融制裁采取什么样的措施呢？大家来看一下，首先是商业凋敝俄罗斯的很多的大商场的很多，我刚才讲了，比如说商业制裁以后，很多大企业、跨国公司的撤离，所以它的商场呢都是空掉了。但是呢，俄罗斯政府也采取了很多措施，就叫金融部门的安全化。比如说外汇管制、利率调节、中小企业贷款支持，再比如说金融和产业体系的本土化，它建立了想取代 SWIFT 体系的 SPFS 系统，用卢布来作为结算体系。再比如说外资和金融服务的多元化，它向东看，西方不亮东方亮，向东方，比如说中国其他金砖国家进行金融交易。俄罗斯反制裁措施主要在4个方面。第一个呢，就是把石油和天然气跟卢布直接挂钩，这样的卢布就有了锚定的一个资产，就是石油和天然气。这样呢，保证了卢布呢不会被因为金融制裁被彻底瓦解掉。第二呢，限制金融交易，比如说外资不能太轻易的撤出俄罗斯。还有呢，外资国有化，如果你想撤出的话呢，就采取国有化的措施。再比如说，他采取了很多的阻断办法，比较极端的阻断办法。他说，任何俄罗斯的企业和个人支持美国的金融制裁或者美国制裁，就刑事化，就是承担刑事责任，承担这个刑法的责任。还有呢，俄罗斯通过了反制的这个阻断办法，一系列的阻断办法。在极限施压背景下，制裁有什么样的启示呢？第一个，在极限施压下面的最大的启示就是全方位的对这个国家采取制裁措施，包括布林肯讲对中国的制裁呢叫做全社会制裁，他没有用极限施压，但是对俄罗斯的极限施压。重点呢，我们应该关注的是金融制裁领域当中从 SWIFT 体系当中剔除的这样一种危险。怎么样对金融制裁采取措施呢？那么有2种措施，一种呢是叫对称性的措施，就是兵来将挡，水来土掩。但是呢，金融制裁是非对称性的，所以呢，用另外一个话叫你打你的，我打我的。也就是说，我们要找到我们可以采取的一些措施，但是呢，肯定不是金融制裁或者是金融反制裁，其他领域的制裁措施。另外呢，要做好从这个国际体系当中被脱钩、被锻炼的这种危险和可能性。所以我们如果来看俄罗斯的反制裁措施，包括资本和金融市场的俄罗斯化，就完全从国际的体系当中剥离出来。另外呢，金融部门的安全化，特别强调经济体系、金融基础设施的安全。再有呢，就是外资和金融服务渠道多样化，就是要跟非西方的国家进行交易。最后呢，就是他提出了一个叫本国金融市场清洁化。就是任何的外资不能够占有核心的金融部门和金融机构。他建立了自己的 SPFS 系统大家知道，在金融制裁以后，俄罗斯有俄罗斯的卢布的一个支付体系，欧盟有欧盟的支付体系，中国也建立了一个CIPS 的体系。欧盟的这个支付体系已经被取消了，欧盟觉得它已经没有办法再走下去了。所以制裁和反制裁的最大后果是什么？就是俄罗斯的经济体系完全从全球化的体系当中剥离开来。 那么对中国的启示是什么呢？我觉得是6个方面。第一个就是中国企业要加强风险防控；第二个要在国际的争端解决机制当中寻求法律的救济手段；第三个，国内法上要进行反制裁措施的法治体系建设；第四个，人民币支付的跨境体系要逐渐的架构起来，也要准备好去美元化、人民币国际化这样一种进程。最后呢，还是要加大全球化的进程，真正的多边主义，扩大这个高水平的对外开放。我的发言到此结束，谢谢。
The topic was, of course, extremely informative, and those of us in Hong Kong, I think until a few years ago, we know very little about sanction and anti-sanction, but it is, of course, something that we are grappling with, and so that was most informative. Thank you so much, Professor Chang. So without further ado, given the time constraint, can I introduce someone who doesn't need introduction, Professor Grenfell Cross. He's going to talk about legislative trends on anti-interference in major Western countries. Thank you, Grenfell.
To get right. Yes, this one is which one? Where's that one? Okay. Thank you very much, Chairman. Good morning, Deputy Commissioner, ladies and gentlemen. I'm most grateful to the Office of the Commissioner and the Department of Justice for arranging this very successful event, and I'm most grateful that the Secretary for Justice has invited me to participate in today's discussions. As this is the second legal forum on interconnectivity and development, it obviously builds upon the foundations that were laid last year when there was a heavy focus on the rule of law in guiding the development of the Hong Kong SAR. And today's forum is, of course, multi-dimensional, and the way in which Hong Kong's national security arrangements protect its way of life from the menace of hostile foreign interference clearly deserves consideration, but it also requires a context. Now, on January the 10th, 2021, China unveiled its first 5-year plan for the construction of the rule of law. It was issued by the Communist Party of China's Central Committee, and it provides that the rule of law is a hallmark of the progress of human civilization, as well as the basic way of governance. Its objective was to overhaul the legal system and shape a distinctively Chinese socialist rule of law by 2025, with a view to its full completion by 2035. Now, the 5-year plan is also significant for Hong Kong, which was required to adhere to the rule of law and uphold both the Constitution and the Basic Law, which enshrines Hong Kong's common law system, as well as the legal rights and protections of residents. Also highlighted by the plan was the need to maintain the long-term prosperity and stability of Hong Kong, an integral part of which is to prevent and oppose the interference of external forces in Hong Kong. And shortly after that plan was promulgated, on March the 11th, 2021, the National People's Congress itself adopted the 14th 5-year plan for national economic and social development, and Hong Kong was again highlighted. It was required to safeguard national security, national sovereignty, security, and the nation's development interests, as well as its own social stability. Once again, the region was enjoined to resolutely prevent and curb interference by external forces in its affairs, and the message hit home. Hong Kong has now discharged in their entirety its national security obligations to the rest of the country, including the criminalization of external interference endangering national security. Now, it is recognized everywhere that when the national security of a country is endangered by foreign entities, remedial measures are legitimate. During the insurrection of 2019-20 and in the years immediately preceding it, Hong Kong's stability was threatened by hostile forces operating domestically in conjunction with foreign entities, and this endangered the survival of the one country, two systems paradigm. External interference by improper means, whether or not at the behest of local residents, is contrary to normal global practice, but let me be clear. When we talk about the criminalization of the act of bringing about an interference effect in Hong Kong, as the Safeguarding National Security Ordinance does, it must also be of a deleterious nature. We are not talking about genuine criticisms of government policies with a view to improving them, legitimate lobbying work, general policy research, normal exchanges with overseas organizations, or daily commercial activities. Those types of activities have always been acceptable in an international city like Hong Kong, and they remain so. However, what is objectionable is conduct that contravenes the principle of non-interference under international law, undermines national sovereignty and political independence, and poses a risk to national security. And this explains why the two 5-year plans which China unveiled in 2021 highlighted the need to counter the dangers that external forces can cause. The consequences of doing nothing and hoping for the best could have been dire, as was seen during the insurrection itself in 2019. And this is why effective national security laws need to contain an extraterritorial dimension, which is of great utility. They help to disabuse bad actors of the idea that they enjoy impunity when they use their foreign bases to try to harm another country and its people. When, therefore, the region enacted the Safeguarding National Security Ordinance on March the 3rd of this year, the importance of deterring foreign threats was recognized. It prohibits, through the use of improper means, collaboration with external forces to influence, for example, the formulation of policies or measures by the Central People's Government or the region's government, the discharge of powers and duties by the Legislative Council and the judiciary, or interference in local elections and related processes. Moreover, the offence of foreign interference endangering national security has been provided with extraterritorial effect, meaning the crime cannot be committed with impunity elsewhere by a local individual or entity. Now, when the policymakers were formulating the offence of foreign interference endangering national security, they did not operate in a vacuum. International models were examined, and they heavily influenced the final product. They included the National Security Legislation Amendment, Espionage and Amendment Act of 2018 of Australia, now incorporated into the country's Criminal Code Act of 1995. And its effect was to prescribe interference in Australia's affairs, and it did so comprehensively. The Australian amendment criminalised covert, deceptive and threatening activities by persons intending to interfere with Australia's governance and political systems or support the intelligence services of a foreign government. It also prescribed acts preparatory to foreign interference, and the law enforcement agencies were empowered to arrest suspects before the country's national security could be prejudiced, and the intended offence is still at the planning stage. The maximum penalty on conviction of intentional foreign interference is 20 years imprisonment, which is far tougher than the maximum sentence for the parallel offence in Hong Kong, which is 14 years imprisonment. However, ladies and gentlemen, it was the UK's foreign interference law which had the biggest impact on the safeguarding national security offence of external interference endangering national security. The UK's National Security Act of 2023 provides that if the offence is committed in a place outside the UK, the person responsible is prosecutable, and this is mirrored in the Hong Kong Ordinance. Although the terminology in the two instruments is not always identical, the objectives overlap. Although, for example, the UK's foreign interference law criminalises acts of what are called prohibited conduct, Hong Kong's law criminalises acts which have, quote, an interference effect. But they are basically the same thing. And both laws require a person to intend the impugned conduct to have an interference effect. Even the maximum sentence of 14 years imprisonment for both offences is identical. However, one notable difference is that whereas Hong Kong's external interference law requires a criminal intent, the UK's foreign interference law applies both a criminal intent and a lower test. And a person is prosecutable in the UK if he is simply reckless as to whether there will be an interference effect, which means that it's easier to prosecute a suspect. In Canada, the risk of external interference has also been recognized, and the law enforcement authorities have been strengthened accordingly. In June 2024, it modernized its toolkit and what is called an Act Respecting Countering Foreign Interference received the royal assent. It bolstered Canada's ability to detect, disrupt, and counter foreign interference threats by modernizing the existing laws. Whereas the Security of Information Act of Canada already criminalized information-related activities that were harmful to Canada, including spying, economic espionage, and foreign influence threats or violence, it has now acquired new foreign interference offences which cover deceptive or surreptitious acts that undermine democratic processes, including foreign interference in governmental functions and political processes. Also criminalised are deceptive and surreptitious acts that harm Canadian interests, such as facilitating the entry of foreign agents posing as tourists, and serious offences which benefit a foreign entity or are directed by such. Now, these reforms have been supplemented with extra powers for the Canadian Secret Intelligence Service. They include an enhanced capacity to collect and use data sets, new warrants to facilitate investigative techniques, and enabling the Canadian Security Intelligence Service to collect within Canada intelligence concerning the intentions and capabilities of foreign states and individuals in the country. And Canada has also intends to establish a foreign influence transparency registry, which will impose a registration obligation on particular individuals and entities with foreign connections. This will become operational on a date to be decided by the Governor in Council. And once it takes effect, those who enter into an arrangement with a foreign principal will need to register their arrangements and disclose any foreign influence activities undertaken if they are in relation to governmental or political processes in Canada, something that goes way beyond anything that exists here in Hong Kong. Now, although the United States has yet to enact foreign interference laws as elaborate as those of its Canadian neighbour, it would be wrong to assume it does not have ample tools available to it to counter what it perceives to be foreign interference in its affairs. Indeed, it was somewhat of a trailblazer in this area, and its Foreign Agents Registration Act of 1938, or FARA, is a very early example of a public disclosure law directed at agents of foreign principals who are engaged in political activities or other specified conduct. Such people are required to publicly disclose their relationships with the foreign principals, as well as the activities, receipts, and disbursements in support thereof. Moreover, the United States Congress is currently considering the Preventing Foreign Interference in American Elections Act, which seeks to beef up the controls which were originally adopted in 1971. If enacted, this piece of legislation would not only bar foreign nationals from directly or indirectly contributing to candidates and political groups, but also to groups that collect ballots, register votes, identify voters, or conduct efforts to mobilize electors. The proposed law seeks to ensure that malign foreign actors cannot directly or indirectly influence US politics and elections, and it echoes those which have been adopted elsewhere. And although not directly on point, it is perhaps worth mentioning that the US has deployed its extraterritorial jurisdiction to pursue foreigners whose activities elsewhere may have endangered its national interests, which is also a useful deterrence tool. It has achieved this by perfecting the protective principle, which enables a country to assume jurisdiction over acts committed elsewhere by individuals of whatever nationality that are considered to endanger its national interests. And in the US, the protective principle has been used against individuals outside its boundaries who have threatened its vital interests, including its security and governmental functions. Its scope is wide, and it has been directed at crimes against the security of the state, such as espionage, or against its money or credit, such as counterfeiting. The judiciary has said in the case of the US and Zia, 1985, that the protective principle enables a country to, quote, adopt laws that make it a crime to engage in an act that obstructs the function of government or threatens its security as a state without regard to where or by whom it is committed. Now, although the protective principle has been incorporated into Australia's foreign interference law and has been invoked in Canada for the offences of espionage and treason, the US has not felt it necessary to do likewise, at least not so far. Before concluding, ladies and gentlemen, let me say a little bit about Singapore. It is not only Hong Kong's regional neighbour, but it also shares a common law legal system inherited from the British colonial era. Like Hong Kong, it has recently introduced legislation to protect itself from external threats. In 2021, the Foreign Interference Countermeasures Act, known as FICA, was enacted, and its purpose is, quote, to protect the public interest by counteracting acts of foreign interference. The FICA strengthened Singapore's ability to prevent, detect, and disrupt foreign interference in its domestic policies, whether conducted through hostile information campaigns or through politically significant persons who could be local proxies. The FICA provides the Minister of Home Affairs with the authority to investigate individuals suspected of being foreign agents. There is also a new offence of what's called clandestine foreign interference by electronic communications activity. And the authorities can compel social media platforms and website operators to hand over data. And whereas acts of general interference are punishable with penalties of up to 7 years imprisonment, this rises to 14 years for acts of interference against a targeted person, which is the same maximum as in Hong Kong. So, ladies and gentlemen, once external interference laws are compared, it becomes apparent that Hong Kong's model is closely aligned to many of them, albeit not always as robust. As we saw in 2019, there are people who will stop at nothing to harm the region, but it is now able to defend itself from hostile interference in its affairs. This, I suggest, is a game changer, and it has been achieved in a way that reflects developments elsewhere. In consequence, Hong Kong is safer, its prospects are better, and its future is assured. Thank you very much indeed.
Thank you so much, Gwen, for excellent presentation as always, and very topical for us, given that the new legislation was only enacted earlier this year. Now, moving on swiftly, last but not least, of course, although he could only join us online, we have Professor Lang Zheng. He's going to talk about the recent developments in the global regulations and governance of artificial intelligence, something that we have also been grappling with. 梁老师，欢迎你。
好的，谢谢主持人，非常高兴有这个机会，也感谢特派员公署，感谢律政司的邀请。今天呢，我有幸呢和香港，我们特别是法律界的专家我们各界的同仁一块来探讨，我们可能在国际法领域相对来讲是一个比较新的议题，我们人工智能的国际治理规则问题。这是我今天演讲的这个题目。我来自清华大学公共管理学院，同时也是清华大学人工智能国际治理研究院的副院长。那么我们今天呢，希望有几个问题呢，跟大家一起来探讨。下一页。请翻下一页。一个是我们人工智能国际治理规则目前全球发展的总体态势。另外一个是我们在这样一个总体态势下，我们可以看到，在这样一些国际规则制定当中的主导权的这样的一些多方的博弈。那么第三个问题呢，是我们在人工智能治理的规则实践上，在一些重点领域和重要领域的探索。最后一个是我们对人工智能国际治理规则和秩序的未来展望。希望有这样一个时间跟大家来探讨这4个问题。好，下一页。那么人工智能国际治理规则建构的总体态势我们总体上来看的话，我们来看具体的内容。下一页。目前的话整体来看，人工智能的国际治理规则的发展，我们认为是处在国际法秩序构建的这样一个早期的阶段。我们可以看到，在联合国的报告里边，已经有这样的一个判断。那么目前以联合国为代表的国际组织还有一些主要的国家行为体 在国际和国内的层面推动不同形式的治理方案，那是尚未形成有人工智能具有法律约束力的一般性的国际规则。那么从3个方面来看，一个是从目前的在国际的这样的一个层面上的人工智能治理规则呢，仍然是以原则共识、国际标准这样一些伦理规则等国际软法律约束为主。那么有一些间接性的治理规则那么在一些相关的具体领域，比如说国际数字经贸规则、跨境数据流动，还有国际网络犯罪的规则，但直接来规范人工智能这个治理的这样的一些风险防范的国际条约和协议这样的一些国际硬法目前是缺失的。那么第2个特征呢，从主体的参与程度来看，目前联合国主导下的多边进程是推动人工智能国际治理规则制定的这样一个主要的多边平台。那么各国之间的这样一些对话机制协商那么也是发挥了重要的作用。那么国际的标准组织还有一些科学家的共同体科技企业呢也积极的介入到了规则的制定当中。但是目前呢我们可以看到已经在这样一个领域呢出现了这样一些我们叫做治理的这种全球竞赛。比如说以美国为代表的一些西方国家以意识形态来进行阵营的划分。那么发展中国家呢在规则的制定上呢处于相对的弱势。所以我们在人工智能的国际治理规则上出现了一个这样的我们叫做碎片化的这样一个竞争化的这样一个状态。那么第3个特征呢是从规则内容来看，目前的国际治理规则呢以伦理规则为主，那么主要重视的一些方面比如说对于风险的防范是大家共同关注的但对于在一些具体领域如何去形成这样一些统一的这样的一些规则这些方面的一些这个进程虽然也有在推进但是这里边存在大量的盲点和这个难点。既有的国际法的规则呢难以去妥善的应对，特别是当叠加到这种国家间存在意识形态、观念认识甚至一些伦理价值观这样所谓的一些差异，那么造成国际规则制定的协调难度非常大那么规则之间缺乏互操作性。好，下一页。那么为了竞争的合作这是我们现在判断我们在人工智能国际治理规则的一个全球格局的这样一个博弈背景下的一个特征就是在竞争这样一个所谓规则制定的主导权。下一页。我们可以看到从多边进程来看的话，从2023年作为一个节点我们的研究认为是进入到一个叫做全球的人工智能治理竞争的一个阶段。那么它的这样一个进程的主导方呢，也从这个多方的进程呢，向多边进程这样去转变。就是从多种利益的这种相关这个共同体，向一个多边的这样一个对话和多边的这样一些谈判这样一个过程去转变。我们可以看到，在联合国的这个框架下呢，推出了那么一系列的推出了一系列的，包括从伦理建议，包括一些像这个一些国家提出的提案，那么加强人工智能的安全、可信和能力建设这方面的国际的这个合作的决议，分别是由美国和中国提出的，还有联合国关于网络犯罪的这方面的特设委员会通过的打击网络犯罪公约以及也就是刚刚9月份未来峰会通过的未来契约和这样几个文件。那么其他一些国际组织，像经合组织发达国家为主的推出的关于人工智能的这样建议书，发展中国家像非洲联盟、像东盟也都对这样一些人工智能的国际治理的原则性的这样的一些这个倡议战略和指南都有这样的一些这个出台下一页。那么从国家间的这样这个多边进程来看的话，包括双边，包括多边比较明显这个特点，是美西方为主导的这样一些小圈子的这样一个建立比如说我们看到在 OECD 的这样一个框架下，作为 G 派那么正式发布的关于这个人工智能伙伴关系的这样的所谓的这个联合声明，还有美英澳之间的 AUKUS 的协议 那么北约的人工智能战略还有像一些这种像第7的广岛这样的议程也有最近的，包括9月份的美国、欧盟和英国这样一些国家那么签署的欧盟委员会的这样一个人工智能的框架公约。这也是第一个到目前为止具有法律约束力的人工智能国际公约虽然现在加入的国家的数量可能还比较少还要有这样一个国家的审批的过程。那么我们可以看到，在这个过程当中，非常明显的是美国是以所谓叫做观念这个一致的这样一个国家联盟的这样的一个所谓意识形态划界去推动这方面的规则制定和建设。包括一些国际条约的这样的一些这个推动。好，下一页。那么以国家行为体为主的这样一些规则制定的这个行动呢，那么主要大国在里边其实是发挥了重要的这个作用也产生比较大的这个影响力。我们可以看到，欧盟第一个在全球通过了人工智能法试图呢在人工智能的规则制定上产生国际引领的这样一个效应。那么美国呢，从早期来看，更多是侧重于人工智能的发展因为它在这方面的具有产业的这种引领和支配力。那么也逐渐过渡到从去年，那么比较重视在人工智能的安全领域的这样一些包括行政令和一些框架标准的这样一些这种制定。那么英国呢，其实是比较强调多方协调的去中心化的这样一个监管框架，那么也发布了这样一些促进人工智能监管的创新的方法，包括推动召开这个布兰切利会议，在人工智能安全方面推动国际这样的一个所谓的共识的达成。比较有特点的还有像新加坡，那么通过制定务实的治理框架和操作指引，特别是发布的首个人工智能治理的框架这种模型还有提供的这样的一些像 Verify 的这样一些评估测试工具去推动人工智能这个治理的这种实践和落实，也发挥新加坡在这方面的第三方的可能这样的一个这种支撑的这样一个枢纽的作用。那么从单边行动和倡议这个角度来看，各国呢依托于国内法和各国在这个人工智能领域的所具有的不同的优势，也发出了一系列的这样一些行动和倡议包括一些相关这样的一些规则的一些制定包括法律的制定。像中国呢，其实发出了在人工智能领域的全球治理倡议，推动了联合国通过的人工智能建设的这样一些普惠的这样一些计划，也有提交的关于规范人工智能军事应用的立场文件伦理治理的立场文件其实中国在人工智能的国际规则的制定上，那么对全球治理这方面的一些立场和观点，应该说是比较系统和完整的表述的。那么看到美国还有包括英国在军事上，在安全上也包括像韩国、日本那么通过一些会议和单边的这样一些行动和倡议那么也在去发挥这个主导权的作用。好，下一页。下一页。那么这样的一个背景下呢，我们可以看到，除了这样一些一般性的我们说人工智能治理的规则这样的一些包括我们说的法律包括这样一些这个指引以外，那么在一些重点领域和重点议题上的一些探索呢，现在应该说已经有一些实践和落地那么人工智能治理相关的一些领域，包括数据，包括算法包括我们对一些叫做风险的这个监控和防范。好，下一页。但整个来看的话，我们可以看到，其实是一个比较碎片化的这样一个状态，并没有形成一个统一的这样的一些这个应该说基本的一些共识。那么侧重于在人工智能的发展包括安全发展、普惠发展上像联合国也包括中国所推动的这样的一些这种建设的一些这个计划包括在多边框架下数字这个经贸规则像新加坡推动的还有一些在低派这样一些这个框架下所推动的在数字经济伙伴关系协议下的关于人工智能相关的一些数据相关的这样一些治理的一些规则的这些建立 这是更加侧重人工智能的发展侧。那么如何更好的去利用这样的一个工具去服务包括经济社会的发展。那么在安全议题上呢，包括一些发展中国家，像阿根廷还有像发达国家美国那么提出的关于致命自主武器的特定常规武器公约的这样一个附加议定书也有在中美在内的国家联合签署的军事领域的这个负责任行动的人工智能行动倡议。那么这是基于不同的这个议题这样一些重点领域的一些探索那么相对来讲是比较具体的针对这样一些领域发展的需求和这样一些安全的风险所提出的这种治理的规则的这种建议下一页。那么在一些比如说伦理领域这样的一些规则和实践的话呢，相对来讲呢，反倒是更多的因为不具有实质的约束力所以国际组织各国政府包括研究智库产业界那么出台了不下几百个这样的所谓叫人工智能伦理的这种建议书。那么大部分呢是不具有强制约束力的这些共识呢，其实在一些基本的一些理念上是具有相当大的一些重叠度的但是呢，也基于各国的这种政治社会文化那么在这种认识上也有一些明显的差异。那么除了国家行为体和国际组织以外，像一些国际这种行业协会特别是像 IEEE、ISO， 那么在人工智能的一些伦理规则和这个标准的制定当中发挥重要的这个作用。下一页。我们把标准呢一般是作为软法来看待的我们可以看到，除了伦理标准以外，像 IEEE、ISO 这样的一些国际性行业协会呢，对于制定人工智能的一些相关的行业标准、技术标准，包括安全治理方面的这个标准，在这方面做了很多工作那么各个国家呢，包括相关的标准化组织，像美国的 NIST 中国的信息技术标准化委员会在人工智能治理的标准框架建设上也做了很多工作。但目前的情况呢是，由于缺乏全球性的这样的一个规则共识，甚至在一些概念术语、流程方法上尚未统一，所以没有能够形成互操作性的技术这样的这个标准的执行机制另外一个值得关注的是，目前在美国的主导下，也是美西方国家那么在大力推动人工智能安全研究所的建设并在这个基础上那么在组建这个 AI 安全研究所的联盟当然，中国也参与到包括第一次布兰切利会议包括韩国的这个安全峰会那么可能也在下来很快在旧金山召开的峰会当中那么各国呢，其实在这个领域呢是具有一些共同的风险的认知的那么怎么去探讨建立全球范围内的统一的这种框架和标准评测方法，可能是现在一个关注的重点谢谢下一页。好，那么看了一下目前整个规则制定的这样的一个情况的话，我们说既有这样的一个应该说这种多方的这样一个在里边的竞争另外又呈现出这样一个碎片化的状态那么未来要想实现人工智能这样一个我们叫做通用技术的健康的一个发展，我们确实是需要一个全球性的治理规则的那么怎么去推动呢？下一页，谢谢。我们觉得有几条可能是我们要关注的，一个是要凝聚人工智能国际治理的一个底线的安全共识其实目前在人工智能极端风险的控制上特别是在安全评测方法这样一些主要的这些分类分级的这样一些标准上我们是亟待去达成这样一个共识的包括它的一些所谓叫做失控性的风险。那么第二个呢，其实我们在控制风险的这个基础上呢，我们更多的是要如何去推动人工智能的健康发展去在发展侧上我们要给予这个市场一定的这个空间对这个技术的这个进步要保持一定的耐心，防止过度的超前的监管，在这方面也有这个必要去达成共识既不能放任不管又不能好像管得过死。那么第三个呢是在联合国框架下，这种双多边机制的这种平台应该是确保我们最大这种代表性的多利益相关方的应该说它的这种利益的这种代表这里边既包括技术领先的发达国家，也包括我们在这方面 有迫切需求，但是相对能力欠缺的发展中国家所以应当在联合国的框架下去建立不同利益相关方有效参与的开放性的对话平台和包容性的治理机制这是我们对人工智能未来国际治理秩序规则这样的一个基本的这样一个观点这样一个看法好，下一页。所以在规则制定推动较快的领域呢，特别是我们觉得安全底线风险防范、透明度、问责，包括人类公共利益这样一些普遍性的技术议题方面，以及普遍认可的打击网络犯罪深度伪造这样一些安全议题呢，可以由各国通过协商来制定国际的硬法、国际条约来予以规制。就像这个网络领域的这样一个打击犯罪这个公约的这个达成那么在一些短期难以达成一致的，比如说我们在发展领域的我们在这样一些可能重点议题的，比如说数据领域的我们可以通过一些软法比如说行业的这个指引、最佳实践，那么标准的这个制定那么在一定的这个弹性的这个基础上，最大程度的凝聚国际共识，也是各界的这个共识去探索建立一个大家具有这个应该说这个最大的这样一个公约数的这个治理框架，为相关的国际规则制定、互联互通奠定基础那么最后呢，也是需要一个多方主体在这样一个框架下我们在国际硬法的这个体系的这样一个基础上那么通过我们一个灵活性的这样一个多方利益共同体去参与的这样一个治理的机制去形成这样一个全球人工智能治理的这样一个规则的体系我觉得在这个里边其实香港其实是可以发挥非常重要的作用。比如说在重点议题上，像在金融领域那么香港就有非常丰富的经验，也有特别迫切的需求也是第一个在出台的在金融领域去运用这样一些人工智能的规范那么一个是为国际的规则制定提供公共服务，另外一个呢，香港可以发挥自己连接东西方的在不同法域的这样一个独有的这个优势去发挥这样一个连接和枢纽的作用，推动国际法和相关的一些条约的这个建设为人工智能健康发展去提供支撑。好的我的演讲就到这里请大家批评指正，谢谢。
Thank you so much. 谢谢梁教授。Q&A session. The staff are really worried that I'm going to go off piece, but I'm going to do that and ask for some questions from the audience. The reason is I see Tony, and when we go to conferences, you usually have some questions on AI or sanction because those are the topic that really interests you. Tony, have you got anything you want to ask the speakers? If yes, can I ask the staff to pass Tony a mic because usually he comes up with really good ideas.
So we have questions from the audience. Could we have one of our colleagues please pass over the microphone to Peggy? Right. So can I please have one of our colleagues? Right.
Thank you, Mr. Moderator. It's been a very, very interesting panel. Thank you very much, everybody. There are really a number of questions, both in relation to sanctions and also in relation to AI. And you see, Grenville was talking about interference by foreign entities and how a country can protect themselves. Nowadays, we have very difficult geopolitical situations around the world right now. Now, the US at the moment, in terms of trade sanctions, it is really sanctioning every country, not just China, which is not friendly to the US, including Russia and so on and so forth, and Iran, not allowing them to use the highest possible military use chips. But at the same time, in fact, they are actually allowing other chips to go out. In fact, there's an exemption system in all the trade restrictions. And that exemption system seems to be quite well used. The question is, how do you think that the US can balance, in fact, their own interests? Because if they don't give exemptions, people like Intel, Texas Instruments, and so on, they have to lay off the staff. So, that's not good for the US. The question then is, but then you need to balance that. What's the right balance? That's the question. The second question is in terms of AI. One of the really difficult things about AI is that it can be weaponized. And it can be weaponized, and in fact, it could be used, to destroy other countries. Now, in terms of weaponization, we have, of course, in international humanitarian law, the Geneva Convention. The Geneva Convention, in fact, disallows countries from using particular types of weapons. Things like cluster bombs at the moment is considered to be so bad, so destructive of humanity, that it is now outlawed by the Geneva Convention. In fact, the US doesn't use cluster bombs, but it sells it to other people, basically. And I don't know who, somebody's been using that, but it sells it. But anyhow, but it doesn't use it itself because it wants to abide by the Geneva Convention. My question is, in terms of AI, is it now the time to consider whether or not we should have a Geneva-type convention in terms of AI weaponization? The types of AI which should be so bad, so destructive of humanity, it should be outlawed by the international community. So 2 questions.
Thank you very much, Tony. Let's start with sanction.
Okay, thank you very much for the question, for a bunch of questions. I think we need to differentiate between sanctioning countries and sanctioned countries. Let's talk about US. Actually, US business community is strongly against the idea of sanctioning on chips and other advanced technologies, export control measures, so on and so forth. And there's a window in the sanction system giving the Samsung and other companies exemptions or waivers so that they can continue to export some less advanced chips to China. So that's about US. On the China side, we also need to differentiate between sanctioned institution and country. The Chinese government actually encourage financial institutions to comply with sanctions so that they can avoid bad consequence. The consequence can be devastating. For example, the worst scenario is sanctioned financial institutions can be kicked off from SWIFT system. So the advice is compliance. They need to take some precautionary measures and improve their compliance system. For example, they can bring in some sanction components in the compliance system. Let's have a database updating the list of sanctioned institutions. Financial institutions are advised to have a know your customer system so that they can avoid the financial sanctions as much as possible. As a matter of fact, there's an opposite strategy for financial sanctions. If you don't have a global business ambition, you don't have to be in the global system. So that some local financial institutions are actually focused on local currency, local business. They don't use US currency at all. They are not afraid of US sanctions. They can still keep relationship with North Korea companies and Russian companies. Thank you.
If I can just follow up, I mean, for Hong Kong, we have been hearing about sanctions because until a few years ago, it was not something that we were interested in. We're not affected by it. We are an international finance center, but we are in the thick of geopolitics. I mean, for a small jurisdiction like us, with heavy economic activities, have you got any advice for our financial institutions, for our regulators, and for the small city in terms of dealing with this type of threats?
I think still we need to divide Chinese government from institutions in Hong Kong. The best advice for financial institutions in Hong Kong is to improve compliance system, to be away from financial sanctions as much as possible. But for Chinese government needs to prepare for the worst scenario. A large number of financial institutions are kicked off from the SWIFT system, like Russia. As a matter of fact, the U.S. government is trying to experiment the financial sanction system to see what's the worst scenario for the U.S. government if the massive financial sanctions are imposed on China, Russia, these large countries.
Thank you very much. Now, and over to Professor Leung. Tony's question about international humanitarian law, should we regulate the use of AI now?
好的，非常感谢刚才的问题啊，因为这个问题啊非常严肃啊，我觉得我还是用中文来回答可能比较准确。对，这是一个非常好的问题。其实，在最早中美之间在对话，在所谓叫做致命性武器这个公约的这样一个框架下，去谈判，那么是否要纳入对 AI 的这样的一个管理？那么其实这个问题就已经被提出来。按照刚才大家可以看到的，在联合国的框架下，包括荷兰包括韩国，那么在几次的这样的一个关于军事领域应用那么 AI 的这样的一个所谓的这个规则，那么也是在谈判当中，对，在推动这个进程，也有一些相应的这样的一些共识的这个达成。所以我觉得一个基本的一个共识的话呢，是我们认为对于叫做 AI 的失控性的这样的一个风险，那么导致在一些领域对它的应用是应该从研究的角度来讲包括我们从国际法的制定角度来看，我们认为它的这个风险是非常高的那么比如说用于核武器的控制所以在这方面包括中美双方的一些专家也是有共识的。我想在国际法的这个层面讨论，那么它是可以和我们禁止生化武器禁止这个包括核武器的这样的一个等于是反核不扩散的这样一个公约的这样一个情况是类似的。对。到军事领域的这样一个分类。其实目前是一个比较大的一个问题，因为 AI 本身是一个特别大的范围，我们可以说像机器人那么我们也可以说是像软件的这样的算法那么在这个里边的话呢，我们去做一个区分和分类，这个是比较困难的，对，包括自动化武器本身和我们用 AI 去进行。这样的一些军事领域的包括我们说的比如说战斗机无人机这样的一些控制所以这些方面其实有大量的问题还没有得到这种解决就是我们这样的风险那么是会有多大会带来什么样的问题？所以在这样一个背景下，即使包括学界在清华的我们有一个叫战略安全研究中心。和美国的布鲁金斯协会已经做过有10轮的民间的对话就是试图去推动在这方面我们有一个关于包括术语，包括我们分类分级的这样一些共识的这样一些一致的认识。我觉得我第一个非常赞同您刚才说的本日瓦公约这样的一个大的一个背景下，我们对人的这种人身安全特别是在战争，包括我们说这种叫做这样一些这种特殊的这种情况下我们去怎么去保护人的基本的这个安全不能够把人的这个命运交给这个不能控制的这样的一些不能做判断的非这个所谓的这种不存在这样一些价值判断的这样一些自动化的武器。这是一个基本的一个共识。我觉得需要去达成那么另外一个就是我们在比较细节的这样一些工作上我们怎么能够去做出这样的一个区分所以这是这个问题的复杂性所在我们需要，但是我们到这样一个过程可能还需要非常长的这个时间去进行这样一个识别去进行这样一个协商去进行这样一个对话我努力去回答您这个问题这个问题确实是一个比较严肃也是比较专业的问题。谢谢。
谢谢梁教授。And over to Granville, last but not least, when we were dealing with the Article 23 legislation, I mean, we have all done the comparison, and you have picked out the ones that are most relevant and most up to date. But one of the criticisms that we often face is that, if you're cherry picking particular provisions, a particular area, I mean, of course it looks fine, but you got to look at the law as a whole and the legal system as a whole. And it is said that, well, if you compare Hong Kong with some of these other jurisdictions, in terms of the package as a whole, we are really not up to it. They say their protection is better. Now, that is a common criticism. And what do you say about that?
Well, of course, as with all these things, it's a matter of getting the message out. The Commissioner made the point this morning that of the 5 connectivities, one of them is people-to-people exchanges. And obviously, through various means, we must explain our legal system, explain the similarities between our national security laws and those in other places, and indicate how our common law arrangements remain aligned to those of the rest of the common law world. Clearly, people who have bad views of Hong Kong are very unlikely to change their minds. But the vast majority of people, in my view, are relatively open-minded. And we must therefore take full advantage of the opportunities that we have to explain what the precise position is. We have a number of legal entities holding their conferences here in Hong Kong this year. The Law Society held a very useful conference in June, the Presidents of the Law Associations of Asia Summit, and I was able to address them and speak with quite a few of the people who attended. They were basically saying that, by and large, people in their own countries aren't too interested in Hong Kong's national security arrangements. But the people who actually attended the conference said, well, you know, we'd like to know a bit more about it. And having been told a bit more about it, they found that whatever concerns they had been allayed. And the Department of Justice, of course, is hosting the International Association of Prosecutors Conference this month, and I'm sure that some of the people attending that will also be interested in how our legal system works, and this will again be an invaluable opportunity for them to speak to practitioners, prosecutors firsthand, and indeed, if they have time, to go around the courts and see that our courts remain aligned to the common law system, and that we apply the standards that have always been applied here in Hong Kong. So it's a matter of getting the message out as best we can. There are some people who will always be indisposed towards us, but I think the broad mass of people are receptive to reason.
You have timed it perfectly, because I was just informed that we have ran out of time. So, ladies and gentlemen, can I ask you to put your hands together for our 3 excellent speakers? Thank you very much.
Thank you very much, our moderator and speakers. So Professor Liang, please kindly stay with us first. And then can I please invite the gentleman on stage? Let's have a good photos with Professor Liang. All right. So please kindly stand closer with each other. And Professor Liang, please look at the camera of your computer. So please kindly look at our official photographer in the center for a good photos. Thank you very much, our moderator and panelists, for your insight. Please kindly remain on stage. All right, a big round of applause for our moderator and panelists, and also thank you very much, Professor Liang, for your insight sharing. Thank you. Thank you very much. And now, ladies and gentlemen, to officially wrap up today's forum, it is my absolute honor to welcome the Honorable Paul Lam Ting Kwok, SPS SCJP, Secretary for Justice, Hong Kong Special Administrative Regions of the People's Republic of China, to come up on stage to deliver his closing remark. Ladies and gentlemen, let's welcome Mr. Lam.
Your Excellencies, distinguished guests, ladies and gentlemen, thank you very much again for participating in this year's 2nd Legal Forum on Interconnectivity and Development. I would first like to express my gratitude to the Commissioner's Office of China's Foreign Ministry in the Hong Kong SAR for co-organizing this forum with the Department of Justice of Hong Kong. OCMFA's support and contribution are invaluable to the success of this event. I would also like to extend my sincere thanks to the Asian Infrastructure Investment Bank, AIB, and especially to the General Counsel, Mr. Alberto Ninio, who delivered an impactful keynote address on the promotion of good governance and high-quality development under international earlier this morning. Hong Kong, China became a member of AIIB in 2017. Arrangement for secondment of DOJ counsel to the legal department of AIIB in the past few years has been conducive to enhancing our collaboration with AIIB and strengthening the development of Hong Kong international legal and dispute resolution services, especially in the financial fields. Following the keynote address from AIIB, the two panel sessions examined the critical importance of legal connectivity in our increasingly globalized landscape, as well as its impact across various fields, from international trade and commerce, dispute resolution, sanctions, to emerging domains such as the governance of artificial intelligence. The experience and practice of Hong Kong in conducting with high-standard international legal rules provide a good illustration for our discussion. Allow me to reflect briefly on today's discussion and Hong Kong's role in these vital developments. Legal connectivity transcends borders, bringing jurisdictions closer and promoting shared prosperity. As President Xi Jinping has noted, the fundamental purpose of advancing foreign-related rule of law is to better safeguard the interests of the country and the people, promote the progress of international rule of law, and the development of a community with a shared future for mankind. China's institutional opening up progresses alongside its development of foreign-related legal frameworks. The rule of law forms the foundation of a favorable business environment. The first session explored Hong Kong's evolving legal landscape, where under the One Country, Two Systems framework, it served as a strategic nexus for trade and commerce and dispute resolution, regionally in the Guangdong, Hong Kong, Macau Greater Bay Area, as well as internationally. In this era of ever-changing global business norms, as China's institutional opening up progresses, Hong Kong serves not only as a super connector, but also provides unique legal services under its legal international arbitration framework. On the importance of the rule of law to mitigate risks and to safeguard Hong Kong's and national sustainable development, the learned speakers have shared their insights into global developments in financial sanctions and anti-sanctions, as well as legislative trends on anti-interference in major Western countries. As artificial intelligence rapidly advances, it transforms industries and economies in a revolutionary way. It also brings with it complex global regulation and governance issues and related risks. As the final report on this subject by the United Nations Secretary General appointed panel concludes, and I quote, "The very nature of the technology itself, transboundary in structure and application, necessitates a global approach." The discussions on this topic today are timely and relevant as we consider how to safeguard sustainable development in an increasingly interconnected world with AI. As President Xi stressed during the 16th BRICS Summit, and I quote, "As the world becomes more turbulent, it's even more important to uphold the banner of peace, development, cooperation, and win-win outcomes." It's my sincere hope that discussions in today's forum could bring out a spirit of cooperation and collaboration in traditional fields like economy and trade, as well as emerging areas like artificial intelligence, with our sustainable development safeguarded by the rule of law. On cooperation and development, aligned with Hong Kong's development of 8 centers as outlined in the National 14th Five-Year Plan, the Department of Justice has taken forward policies to strengthen Hong Kong's role as a leading legal and dispute resolution hub. The staunch support of the Central People's Government in strengthening the city as a center for international legal and dispute resolution service in the Asia-Pacific region under National 14th Five-Year Plan can be demonstrated by the establishment of the International Organization for Mediation Preparatory Office last year. The IOMAC Preparatory Office has successfully facilitated the conclusion of the negotiation on the Convention on Establishment of the IOMAC last month. A decision has also been made by all the negotiating parties that a signing ceremony of the Convention will be held in Hong Kong next year, and the IOMAC headquarters will also be situated in Hong Kong once the Convention has entered into force. As the world's first intergovernmental international legal organization dedicated to resolving international disputes through mediation, IOMAC is important for the implementation of settling international dispute by peaceful means as set out in the United Nations Charter. Upon its establishment, the IOMAC will provide friendly, flexible, economical, and efficient mediation services, thereby building Hong Kong as a capital for international mediation. Apart from exciting development on IOMAC, we also continue to enhance our collaboration with prominent law-related international organizations, such as the International Institute for Unification of Private Law, the UNITRA, with which we organized this year's Asia-Pacific International Private Law Summit yesterday. We are also in active discussion with UNITRA for the possible establishment of its liaison office in Hong Kong in the near future. These forms of collaborations enable Hong Kong to contribute to and align with international standards, thus enhancing its appeal as a global hub for dispute resolution. In addition, with the support of the Central People's Government and assistance of OCMFA, the Department of Justice has put in place programs to second local legal talents to several law-related international organizations, including the UNITRA. Through participating in the work of such international organizations, local legal professionals can enhance their knowledge of international legal matters and develop global vision. Nurturing Hong Kong's legal talents is crucial for the sustainable development of the legal community, for consolidating our position as a leading international legal and dispute resolution service center, and for the long-term development of the rule of law, matters to which the central authorities and the Hong Kong SAR government have attached great importance. Following the announcement in the Chief Executive 2024 Policy Address, the Hong Kong International Legal Talents Training Academy will be officially launched on this Friday, Day 5 of the Hong Kong Legal Week. To make good use of Hong Kong's bilingual common law system and international legal status, the Training Academy will regularly organize practical training courses, seminars, international exchange programs, and more to promote exchanges among talents in regions along the Belt and Road region. It will also provide training for talents in the practice of foreign-related legal affairs for the country and cultivate legal talents to be familiar with international law, common law, civil law, national legal systems, and other legal areas. In future, our department will make use of this capacity-building platform to enable practitioners from different jurisdictions to exchange ideas on promoting the culture of harmony. Looking to the future, we are reminded of the traditional Chinese saying by the Confucius. In Chinese, it's 君子和而不同. I think in English, a gentleman seeks harmony, not uniformity. This philosophy encourages us to pursue a shared vision despite our differences, and it's crucial for enhancing interconnectivity and development in building a community of shared future for mankind. In our interconnected world, such harmony through diversity is essential for achieving lasting success and mutual respect across boundaries. Hong Kong's dedicated efforts in aligning with and contributing to international legal standards, experience in international dispute resolution, as well as its commitment to legal capacity building could leave a positive impact as the world navigates through complex challenges. As China moves towards deeper institutional opening up, Hong Kong has a significant role to play in facilitating international engagement and promoting the progress of international rule of law. In closing, my sincere thanks to all speakers, participants, supporting organizations, colleagues at the OCMFA and the DOJ for making this forum a success. And I look forward to your support for the third Legal Forum on Interconnectivity and Development next year. Thank you very much.
Thank you very much, Secretary Lam, for your closing remarks to officially wrap up today's forum. Please be seated. Thank you very much. So, ladies and gentlemen, this concludes the second legal forum on interconnectivity and development. 各位来宾，第二届融通与发展法治论坛已经圆满成功。仅代表外交部驻香港特别行政区特派员公署以及香港特别行政区律政司，向各位主礼嘉宾、还有讲者以及我们的主持人表示衷心的感谢，也谢谢我们现场还有线上的来宾积极参与。 现在也希望大家可以为本次论坛提供意见，请扫描一下我们场内或者屏幕上面的二维码，填写问卷。这个二维码跟之前在讨论环节所用的二维码是不一样的，请确保扫描正确的二维码。离场的时间，请大家检查随身物品，如果有借用同声传译耳机，请交还入口处的柜台。 另外，如果需要取得 CPD 学分或者高级法律进修学分，一定要填写问卷，还有到接待处登记离场。那么再次感谢大家的参与，期望在香港法律周2024其他活动和大家见面。Thank you once again for joining us, and we look forward to seeing you again in other events of Hong Kong Legal Week 2024. Have a wonderful day. Thank you very much.